not shown in the cause list. So, my lord, matter will be listed on Thursday, showing the name of the respondent number, advocate of the respondent number 7, my lord. Mr. A. Raskwa.
You are Mr.
JC Gogoi, my lord. I am for the petitioner.
Heard JC Gogoi, Leonard Counsel for the petitioner.
Item
Is to direct to reflect the name of Mr.
A. Raskwa, advocate for the respondent number 7.
The respondent number 7 in the process. And is the matter after 1 week.
No, my lord, urgency is there, my lord. So,
Then why are you adjourning?
Monday, my lord. Otherwise, the advocate is not appeared, my lord, so matter cannot be.
31st.
May I please, Your Lordship? May I pray for listing of a motion matter day after tomorrow, Your Lordship? We have filed it yesterday, Your Lordship. We have some urgency.
May I please, Lord, this matter, my lord, regarding that college students case, my lord. I may pray that matter be taken up on Thursday next time,
First,
27th. my lord.
not this week, next week. Second.
But can it be on 4th, my lord?
Okay, 4th.
My lord.
Well, in item number 7, we have filed an appeal in opposition on 21st regarding the admission in Medical College of Assam. Can it be brought it to the record, madam?
Okay.
My pleasure. Regarding item number 7. See, I pray the matter be taken day after tomorrow, Lord. We
Why?
will file our agenda activity today, Lord.
You're for petitioner.
I am for the petition.
Any urgency is there?
Lordship.
But tomorrow the counseling will start. So if they wanted
Tomorrow, then, Lordship. The matter will be taken up tomorrow morning. First up.
You are Mr.
A. Dhanuka, Lordship.
On request made by Dhanuka.
in that case, Lordship may direct me that the affidavit that we have filed on 21st, it should be on record on that day.
Yes, the matter. Tomorrow, day after.
Tomorrow, Lordship.
Okay, tomorrow's date. In the meantime, it is directed to place on record the affidavit in opposition filed
Filed by
by
respondent 1 and 2.
the respondents 1 and 2.
May I please, Lordship?
Yeah.
Lordship, I beg to mention item number 40, Lordship, 40. Lordship, in this case, I was actually directed to place some instruction, Lordship, but I could not obtain the instruction fully. So matter may be deferred for 4 weeks, Lordship. I may be allowed 4 weeks time to place the correct instruction.
Have you taken the consent of the other side?
Yes, Lord.
Taken consent
Consent, Lord, I have taken.
Item 40, I am saying.
for the petitioner?
I am for the petition.
Oh, you are for the petitioner?
Petition.
Okay, on request made by
P. Sharma, Lord.
P. Sharma, Leonard Counsel for the petitioner. Release the matter after 4 weeks.
4 weeks, Lord.
In item number 20, my lord, I have filed an reply affidavit, my lord. Kindly, it may be called for record.
Yeah.
Okay.
May I please, Your Lordship? Regarding item number 41 of today's list, Your Lordships. I may withdraw the repetition, Your Lordships.
Yeah, Mr.
H. Boro, Lordship.
Mr. H. Barwal and the counsel for the petitioner appears for withdrawal of this petition. Who appears for Education Department, Secretary? Mr. B. Kaushik, Learning Standing Counsel, Secretary, appears for the Secretary. This petition is dismissed on the withdrawal. Are you also?
Yes, Lordship.
Are you also in view of orders? Are you start this post?
Deeply.
Wait to the Lordship. So I am appealing for listing for sharing matter. Matter
What?
relating to pensionary benefit. Matter relating to pensionary benefit. Lordship. Sharing is this, sir.
10th August.
May I please, Your Lordship? Item number 21 and 47. In item number 21, we have the consent of the petitioners, my Lordship. To adjourn the case.
To?
Adjourn the case for today. Yes, the engaged counsel is.
You are not giving any mention slips also. Have you given a mention slips?
No, Your Lordship.
This is the problem. There's already a notification to that effect, isn't this? From tomorrow, I'm not adjourning matters if you don't give mention slips. Yes,
Right, please, Lordship.
item 21?
And 47.
No, 21, what you want?
The matter may be fixed in next week.
You are for?
Respondent number 1 and 2, PJ Pukan.
Have you informed the petitioner's counsel?
Yes, item number 21 we have mentioned.
You've taken the consent?
Yes, item 21. But in item 47, we have not taken consent.
Then you take your consent and come. Item 41, on request made by Mr.
A. Rahman.
A. Raman, Leonard Counsel for?
Respondent number 1 and 2 in item 21.
Respond number 1 and 2. Please the matter after one.
My please, Your Lordship. Lordship, I beg to mention for listing orders method on 3rd of August.
Why third?
I'm up.
My lord, let the matter be listed on Friday, my lord. This is a case of withdrawal, my lord, and case in the year 2020.
Next
Till
week.
today, he could not get
Next week, next week.
next week. Highly obliged. My lord, date may be kindly given.
Fourth.
Highly obliged.
May I please, Lordship? Lordship, I beg to mention item number 9, Lordship. Kindly matter of withdraw, Lordship.
You want to withdraw?
Yes, Lordship.
You are Mr.
Yes, Islam, Lordship. Lordship, I will file fresh petition, Lordship.
Mr. S. Islam. Your name is not there.
I'm appearing on behalf of Ami Mahmood, Lordship.
You are the counsel appearing on behalf of M.U. Mahmood, you are the counsel for the petitioner, press for withdrawal of this petition. With liberty to file affairs. Who appears secretary? Mr. B. Kaushik, learned standing counsel, appears for the secretary report. With petition is dismissed on withdrawal with liberty as respectful.
Much obliged, Lordship.
May I please, Your Lordship? Let's say back to item number 5, Lordship. Let's say in this matter, respondent number 3 has filed affidavit, Lordship. We need some time, Lordship.
Let it reach, please.
May I please, Your Lordship? Lordship, I beg to mention item 29 of the daily list. Lordship. In this matter, we have to file our rejoinder affidavit.
Wait for your turn.
May I please, Your Lordship? I'd like to mention item number 39. Lordship, with the consent of the other side, kindly please take this matter after 1 week.
You've also not given your mention slip, isn't it?
Lordship,
You have to give your mention slip. Today I'm permitting you from tomorrow, no more adjournment without mention slips. Item 39, you are for
I'm for the petitioner.
your MS,
PJ.
MSP day, that will constitute on request made by MSP day, that will constitute petitioner. List the matter after
1 week.
1 week.
Obliged.
May it please, Your Lordship. I beg to mention item number 42, 43, and 45, all are 10 matters, Your Lordship. With the consent of the other side, matter may be adjourned for a week, Your Lordship.
You are for,
I am for petition, Your Lordship.
here also no mention slip. You have to give your mention slip from tomorrow. Your MS,
You, sir, Your Lordship.
you are praying on behalf of
B. Haklari.
MSU so and so, that the council, appearing on behalf of Mr. B. Haklari, that the council. On request. Yes, the matter after
After a week, Your
after 2 weeks.
oblige, Your Lordship.
Please, Your Lordship. Lordship, I prefer listing of two writ petition, Lordship, and 1 contempt petition on Friday or any other day. Lordship. One is regarding non-payment of salary, Lordship, pension, and other is cancellation of provincialization.
7th August.
And Lordship. Obliged.
Lordship, I beg to mention item 66 of today's daily list, Lordship. It's a review petition, Lordship, and there is a direction to the director, Lordship, to consider the case within 1 month, Lordship, and Lordship, the 1 month will.
It's a review application. My lord had given 1 month time for them to pass a fresh order. Some aspects, my lord, will also be required to take and brought it on record. Today may not be possible. If your lordship can take it up on Wednesday, my lord.
On request made by UK Nair, and it's a very consequent. B6.
Much obliged.
May I please, the Lordship, my lord, I beg to mention for listing of a matter, my lord, for admission on 28th, my lord.
First,
Oblige, my
second,
oblige, my second, my oblige. Yeah, please, my lord. Lordship, item 29. In this matter, we have to file our affidavit.
wait for your turn. I told you to wait for your turn.
I apologize.
Item 1 of daily list, motion.
May I please, lordship?
This- The file is-
Lordship, in that matter, the engaged counsel is absent today because of medical emergency, Lordship. So Lordship may kindly pass over the matter for the bill.
Who's the engaged counsel?
R.H. Chaudhary, Lordship.
On request made on behalf of R. H. Chaudhary, let me consult for petitioner. Yes, after 1 week.
I'll acknowledge, Lordship.
So,
May I please your lordship? Matter is regarding appointment on compassionate ground, lordship. The petitioner application was initially it was not placed before the DLC, lordship. Thereafter, as per order of this honorable court, lordship, it was placed in lordship. It was placed, lordship, and by impugned order, page number 22, lordship, annexure 4, the
age,
22, lordship, of writ petition.
yeah,
That was rejected, lordship, saying that it spent its force, lordship. On instruction, lordship, the instruction, they filed their affidavit in opposition, saying that from 2012 to 22, they rejected my claim on only one ground, lordship, lack of vacancy. Last 10 years, there was lack of vacancy. That's why my case could not be considered. It is totally mechanical, lordship. Throughout 10 years, that was not done, only on the ground that every time it was only the rejection was only for that the vacancy was not there.
where is the statement?
Lordship, they have filed that affidavit in opposition. That must be in the file, lordship.
Yes,
They have annexed all the DLC resolutions saying that
Lordship, kindly come to page 57
kindly
of our
see.
affidavit in opposition. Last page, Lordship. There is a fifth DLC meeting, Lordship. Prior to that, fourth time is
all the times only for lack of vacancy, lordship. Throughout last 10 years, lordship, they are 22, they're saying that last 10 years, my case was placed before the DLC. 4 times, all the times for lack of vacancy, my case was not considered. But lordship, in 2015, there is a circular, I have filed my reply also, lordship. In 2015 circular, there is a scope for accommodation in another department also, lordship. This is a mechanical rejection, lordship. Only to sake of reject my case, throughout these 10 years, they're saying that lack of vacancy, lack of vacancy. This is very easy way to reject.
where's that? It has spent this force, page 22.
Yes, lordship. That is the first impugned order. I mean, in the writ petition, lordship. In 2022, they are saying that, lordship. Whereas in 2015, there is a circular in column 15, there is a scope for accommodation in another department in case of lack of vacancy in the department itself.
Where is this DLC minutes?
Which one, lordship?
Page 21, 22.
Lordship, they have annexed all the DLC minutes in their affidavit in opposition, lordship.
No, where's that minutes, which it says that lack of spent this force?
Lordship, page 57, Lordship, of our affidavit in opposition. Last page, Lordship. That is the 5th time this case was placed, Lordship. Serial number 2, follow-up again.
Last page.
Page?
Page 57 of our affidavit in opposition. Filed on behalf of respondent number 4, Lordship.
That. How many DLCs were there?
Altogether, 5 DLCs. This is the 5th one, Lordship.
In all the DLCs, the reason of rejection was lack of vacancy.
Let's see all the DLCs.
Lordship, it is there in their affidavit.
First DLC is
21/4/2012.
then here it says
In our affidavit, page 42, Lordship.
what does it say here? Where's the relevant portion?
Page 44, Lordship.
Where's the consideration of the petitioner?
Actually, Lordship, that consent period of time, Lordship, those whose name has been recommended, their name has been reflected only in the minutes, Lordship. Last week also, Lordship have come across of such DLC minutes from the Lakhimpur district, Lordship. In all the
Minors
minutes,
itself,
Lordship,
it was
only
reflected,
recommended
but their
candidate's name
statement
is there.
said that.
Only in the last DLC minutes meeting, Lordship.
And the next DLC after 2012,
2012, after Lordship, page 45, 16/3/2013.
In page number 48, Lordship, remark was not, there is nothing written in the remark portion, page number 48.
serial number,
Similarly,
no, serial
Lordship,
number,
Serial number
1, Lordship. Page number 48. Similar manner, Lordship, there wasn't any mention in the remark portion, last right-hand side.
page 48.
Page
Lordship.
48, Lord.
Nothing is written. This lack of vacancy is the afterthought, Lordship. On that day, there wasn't any recommendation or anything, Lordship. Thereafter, again, page number 51, Lordship. Next DLC 18/12/2013, Lordship. Page number 51. Same format, Lordship. Nothing was written in remark portion, remark column. Page number 51 may kindly be seen.
Where's your name?
Page number 51, Lordship, 1. Pallab Saikia. Remark portion was empty, Lordship.
The next,
Next, Lordship,
Page 55, Lordship.
page number 55. Here also, there wasn't any recommendation or rejection, anything written in the remark column.
Page 57 for DLC minus
Lack of
34
vacancy
and 22.
Afterthought, Lordship. On that day, on those days, there wasn't any written recommendation or rejection by the DLC. It is reflected in the DLC minutes itself, Lordship.
It's not a matter of after thought lordship, those period of time lordship only recommended candidate's name were reflected in the DLC minus.
No, his name was also reflected,
No,
but the remarks column shows nothing.
Reason,
it was lordship.
reason should be there, lordship.
And for placing the case of the petitioner before a DLC lordship. If your lordship kindly see the head note lordship.
Page.
Page lordship 14 44 lordship. Head note kindly see lordship. Statement showing proposal for appointment on then lordship page 48 also lordship.
44, what does it say?
Statements showing proposals for appointment on corporation ground placed before the DLC 21/4/2012.
Then,
But what I'm trying to satisfy your lordship, but his case, as his case was not could not recommend due to a lack of vacancy, his name was not reflected in the DLC minute.
no, it's there in the DLC minutes of 21/4/2012.
The reason of rejection, lordship, that must be there.
His name is there.
Lordship may kindly see the annexer 42 and annexer 1 page 42 lordship. The recommended candidate's name has been reflected like this only.
No, that's fine, that we have seen, but the last page, page 44, and here my record is page 45.
Yeah, 44 lordship.
Yeah, Palab Saigya,
Yes, yes, lordship.
remarks.
That is blank.
That's what I'm asking. And the last one, it says 24.
Yeah, yes, lordship, page 57.
Okay. Third MS,
As Kanun go, lordship.
Kanungo and also to the petition. Also heard, who secretary? P. Kaushik, understanding council,
1, 2, 3.
secondary division for respondents, 1, 2, and 3.
I'm
And
for
Mr. S. R. Barua, learned council, learned government for respond number 4. Stop. Para. The father of the petitioner led Vinanda Chandra Saikia while serving as an assistant teacher in Bulbari High School, Bulbari, Bokanadi in the district of Lakhimpur, Assam. Died in harness on 3/11/2011. The petitioner drafted made an application for appointment on compassionate grounds on 2/1/2011. Stop. Who is this court's order?
Lordship, page number 18 onwards. The relevant portion, page number 20, lordship.
As his case was not placed before the concerned DLC for consideration, comma, petitioner approached this court by filing the PVC number 1106 of 2015, which was disposed of by order dated 3/3/2014, directing the respondent to place the application of the petitioner And thereafter, take a decision in the matter. Stop. Para. The case of the petitioner was drafted, placed before the DLC of Lakhimpur district on 21/4/2012. However, his case could not be rejected due to lack of the pension. Stop. The petitioner's case was taken place before the concerned DLC. No, was the concerned DLC. Again, consider the case of the petitioner on 16/3/2013. However, his case was not recommended without giving any reasons. Stop. The petitioner's case was again considered by the concerned DLC in his meeting held on 18/12/2013. However, his case was again not recommended without giving any reasons. Stop. Was the 2014
Lordship, page number 52 of their affidavit.
the DLC, concerned DLC, again consider the case of the petitioner in its meeting held on 25/7/2014. In the said meeting, the case was again the case of the petitioner was again not considered without giving any reasons. Lastly, the DLC,
56 page.
concerned DLC, in its meeting held on 30/4/2022, considered the case of the petitioner and rejected his case on the ground that he had spent his votes. Para. A consideration of the DLC minors held on 21/4/2012, 16/3/2013, 18/12/2013, and 25/7/2014 would indicate that the case of the petitioner was not considered on 21/4/2012 due to lack of vacancy. And thereafter, the three other meetings of the DLC, i.e. 16/3/2013, 18/12/2013, and 25/7/2014. His case was rejected without giving any reasons. Lastly, in its minutes dated 34/2022, the concerned DLC rejected the case of the petitioner on the ground that it has spent his votes. No, continue. What transpires from a perusal of the minutes of the DLCs that had considered the case of the petitioner is that no appropriate reason was given for rejecting the case of the petitioner. And the last DLC rejected his case on the ground that it was spent. In the absence of any reasons being given for rejecting the case of the petitioner, The DLC in its minutes dated 30/4/2022 could not have rejected the case of the petitioner on the ground that the expiry is. Inasmuch as if there was any delay, the same cannot be attributed to the petitioner, but to the concerned authorities who had rejected the case of the petitioner without giving any reasons. In that view of the matter, the matter is again remanded back to the concerned DLC for the consideration of the case of the petitioner in accordance with law in its next immediate sequence, and also taking into consideration clause
Lordship, clause 15, Lordship, in my affidavit also. Page number
clause
53 of
15 of the office memorandum dated 1/6/2000
page number 53 on my affidavit.
with the aforesaid observations and directions to petitions.
Lordship. Keep your license.
Wait, please, your lordship. Lordship, we have challenged the impugned minutes of the DLC, my lord, 28/2021, my lord, page 48, my lord. Relevant is page 49, my lord.
Page
Page 49, my lord. Relevant portion, my lord. Number 1 column is the rejection order, my lord. Page 49, my lord.
yes.
My lord, the petitioner's case,
Serial number?
serial number 1, my lord. District Elementary Education Officer Sonitpur.
Yes.
DLC has discussed and re-examined the case as per government OM number ABP so and so dated 1/6/2015 and peruse the Honorable Guwahati High Court's order dated 7/2/2020 in writ petition number 8211/2018 in respect of C. Rinku Keout, son of Chotlal Keout, village Sidubari, post office Gelapukuri, district Biswanath. The DLC decided not to recommend the case of the case as Chotlal Keout died on 3/10/2004 after the cutoff date 22/6/2004 as per applicability of APS rules 1992. My lord.
What is this?
My lord, APS rules are the rules provided for the persons, my lord, affected by the extremist violence, my lord. These rules provides for compassionate appointment to the concerned person whose family members has been killed by the extremist, my lord. In this present case, my lord, the petitioner's father, while serving as assistant teacher in Birsa Srimati LP School under the Block Elementary Education Officer Bihali, my lord, was shot dead on 4/10/2004, my lord, by the extremist, my lord, mercilessly by. While the petitioner was minor at that point of time, my lord. And after becoming major, my lord, he applied before the respondent on 17/9/2017, my lord. Thereafter, nothing has been done by the respondent authority. Thereafter, the petitioner approached before this honorable court by filing writ petition number 8211 of 2018, my lord.
Where is that order?
My lord, that order I have annexed page 44, my lord. It starts from page 44, my lord. Relevant is page 46, my lord. Page 46 is the relevant portion, my lord. Para 4, my lord. This court directed the authorities to sympathetically consider the case of the petitioner, taking into consideration that his father was a victim of terrorism, my lord. So the only prayer before your lordship is that, my lord, the petitioner's matter may be reconsidered by the respondent authority.
Yes.
Yes, Lordship, earlier order was clear, but authority has considered his case in terms of that APS rules, Lordship.
So under the normal completionist.
Yes.
You could
Because
have
in
reconsidered.
earlier round of litigation, it was clearly stated, Lordship, in the order, but authority has wrongly considered his case under that APS rules, Lordship. Remand back to the authority, Lordship, in light of the earlier order, Lordship.
Heard, Mr.
Yes, Upadhyay, my lord.
S. Subadiyal and the council. Also heard. Who appears for respondent one?
A for Panel.
Relief and rehabilitation. Relief and rehabilitation. Department.
Relief, Lordship, I'm not appearing for, it will be the government advocate.
Some relief and rehabilitation department. Lordship, I can appear.
He'll appear.
Mr. S. R. Barwal and the government could appears for respondent number 1,
4 and 6.
4 and 6, and Mr. A. Fukan and the standing council.
Elementary education.
Elementary education appears for respondents
2, 3,
2, 3, and 5.
2, 3 and 5.
Stop. The petitioner's father, while serving as an assistant teacher, in which school?
Birsa Sri Smriti LP School, my lord.
In Birsa
Smriti.
LP School. Under the block elementary education officer, Bihali Elementary Education Block. Was killed by extremists on 14/10/2000.
Next
Stop.
person, number.
After
Next number.
the petitioner, after attaining majority,
Yes, my lord.
applied for appointment on compassionate grounds on 17/9/2017. Stop. The concerned district level committee in its meeting held on 19/7/2018 rejected the claim on the ground that the petitioner's father died on 3/10/2004. Which is after the cutoff date, i.e. 22/6/2004. As per the policy framed by the state government to grant appointment to victims of extremism. Stop. Being aggrieved, petitioner approached this court by filing WBC number 8211 of 2018, which was disposed of by order dated 7/2/2022. With the following directions, page 46, A to A. Stop. Para. The case of the petitioner was again recommended, was again considered by the concerned district level committee on 28/2021. Stop. However, his case was not recommended on the ground that the father of the petitioner died on 3/10/2004 after the cutoff date of 2/6/2024, 2/6/2004. In terms of the FPS rules 1990. The agree petitioner is again before this court by way of the president. Para. A perusal of the directions passed by this court in WBC number 8211 of 2018 clearly indicates that if the case of the petitioner cannot be considered under the policy framed by the state government to grant appointment to the victims of extremists, comma, his case can be considered for appointment under the normal scheme, for appointment under die and harness, for appointment on compassionate grounds. Stop. Stop. A further direction was also issued to the respondents to consider sympathetically the application of the petitioner for appointment on compassionate grounds as a son of a victim of terrorism, and also keeping in mind that the petitioner's father was serving as an assistant teacher of a government school who was killed mercilessly by the extremists. Stop. A perusal of the minutes of the meeting of the district level committee, Bishwanath district, dated 28/2021, would indicate that the rejection of the case of the petitioner was not in terms of the directions passed by this court in the WBC number 8211/2018. By the it's not in. What did I say? There was. In its order, dated 7/2/2022, passed in WBC number 8211 of 2000. Inasmuch as rejection was on the same ground as that of the earlier DLC that held its meeting on 19/7/2000. In that view of the matter is remanded back to the DLC Bishwanath district for a reconsideration of the case of the petitioner in the normal scheme of compassionate appointment by considering his case sympathetically, keeping in mind that the father of the petitioner was killed by extremists while serving as assistant teacher of a government school in his next immediate city.
I'm highly obliged, ma'am.
With petitioners if possible.
Highly obliged, ma'am.
Or
So last occasion also they did not appear, Lord. We are challenging the minutes dated lordship 23/11/2017 lordship. Relevant parties at page 37 lordship.
None appears for the petitioner. Mr. Ezra Barrow, learned counsel appears for respondents 2 and 3.
Lordship.
Secondary assets.
I am for 2 and 3.
I am for one,
SMDC, learned standing
1,
counsel.
4 and 5.
Secondary division appears for respondents
1, 4 and 5.
1, 4, and 5.
I have received that those honorable court has directed to me for the BLC minutes I have received.
We'll give them one more chance.
Lordship.
Please, Commander, again after 2 weeks.
5.
Please, your lordship. So in this case, we have received the affidavit in opposition filed by respondent number 3, lordship. But we need 2 weeks time, lordship, for some instruction, lordship.
Mr. S.
B board, lordship.
We will go ahead and run a counsel for the case for 2 weeks time. We are not going to receive instructions. Please, after 2 weeks.
2 weeks, lordship. Most of it.
Your lordship may kindly see rule 14 of 19.
66.
And 6 and 66 is same. Your lordship may kindly take up 66.
Item
6 and 54.
Item 66 is already mentioned.
Mentioned to come up along with this 6.
Item 64 is the same.
It is 64,
Not 64, 66.
is a review petition.
No, 66 is not a writ petition.
No,
4076.
No, that is 64.
that is
That is
item
item 64.
64.
Which one?
66 is 64 হয় আপনার।
Oh, yes, 64. The lordship may take up 64. Already, your lordship kindly see by rule 14.
One minute.
66 will be good. Yeah? My lord, if your lordship looks into rule 14 of 2018 rules. Page 35. Rule 14 of the 2018 rules. My lord.
Page,
No, rule 14 of the 2018 rules, education. Assam Secondary Education Provincial Election Schools Rules 2018. Page 35, I think. It should be page 35.
Assam,
Secondary Education Provincialized Schools Rules 2018.
yes.
Rule 14 recruitment to the post of headmasters, superintendent and procedure thereof. The post of headmaster of high schools and superintendent of high madrasa school shall be filled up by promotion from candidates amongst the graduate teachers as per district-wise seniority list on the recommendations of the district selection committee constituted under so and so. The selection of headmasters and superintendents shall be based upon seniority and satisfactory annual confidential report for last 3 consecutive years as per procedure prescribed provided under sub-rule 3. So this has been initiated by BTC, madam. This whole procedure, your lordship will kindly see page 44 of the writ petition.
Yes.
Well, the subject is preparation of district-wise seniority list of graduate teachers. Then first paragraph, my lord, with reference to the subject cited above, I am to state that vacant post of headmaster, headmistress, a superintendent of provincialized high schools, high madrasa under BTC area will be filled up by promotion among the graduate teachers as per district-wise seniority list on the recommendations of the departmental promotion committee constitution by the BTC. Then I'm leaving in my last paragraph, I'm reading. Therefore, you are requested to prepare district-wise gradation list of graduate teachers having BT, BA, Parangat and so degree of provincialized high schools under your jurisdiction in the enclosed formats as per Rule 24. So accordingly, the process was initiated in BTC. Now page 45, your lordship will kindly see. Next page. The inspector writes to the says, my lord, in pursuant, page 45. Your lordship got it.
Yes.
In pursuance of the letter number so and so, a final combined seniority list of graduate and postgraduate teachers for promotion to the post of vice principal, headmaster, superintendent, assistant masters of the provincialized high secondary schools who were completed 10 years or more teaching experience as postgraduate and graduate teaching having BT, BA, Parangat, Nishanat degree as per norms published by BTC authority in respective schools are hereby published for informations to all concerned. Objections, if any, relating to this omissions or wrong insertions, error in the draft graduation may be submitted on or before 23/8/23. Now, my lord, in this process, my lord, the process initiated, process continued, then your lordship will kindly see page 51. Ultimately, on the basis of the thing, they are supposed to look into ACR. So, page 51, the inspector of schools, my lord, last paragraph I am writing it, my lord. You are also requested to submit the ACRs for the last 3 years in prescribed format for promotion to the post of headmaster, headmistress, and superintendent of provincial schools under this inspectorate honor before so. So accordingly, this was submitted and my lord, final gradation list has been made. Page 53. Page 53, Office of the Inspector School, Baksha District so and so, consolidated statement of postgraduate, graduate teachers of provincialized higher secondary schools for promotion to the post of headmaster and superintendent. So the list, my lord, is 54, 55, 56, 57, where the petitioner's names are also there. This gradation list has been finalized.
Yeah.
Then thereafter, my lord, they are to promote us. But instead of doing that, my lord, what they have done is page 61. Again, they said you submit the list of gradation list of teachers for promotion. So they are reinitiating the process. Page 61. Director of Education to the Inspector of Schools with reference to the subject cited above, I am to request you to submit the gradation list of eligible teachers for promotion to the vacant post of headmaster. This process they have initiated, my lord, they have completed the process. Now then thereafter, instead of promoting the petitioners, they are reinitiating the process without cancelling the earlier process. This is, my lord, totally non-application of mine. And again, my lord, next page, page 62, to the headmaster, headmistress, so and so by the inspector of schools regarding submissions of the gradation list of graduate teachers for promotions to the vacant post. You have already taken graduation list, taken the ACR, last 3 years ACRs, made the gradation list. Now again, you are trying to initiate the process, totally completing one of the, ignoring the process already completed earlier as per the gradation list. So I pray my lordship may issue notice, let the matter come up after 2 weeks. In the meantime, my lord, this page 61, 62, they should not take any actions.
I don't know. Without stay, my lord, so that may be given for 1 week.
1 week,
1 week, my lord.
you want to take
Instruction.
instructions?
Yes, my lord.
Then let us,
No,
we hear what
without
instructions.
stay, my lord.
Yes, but in the meantime, they should not proceed with this.
No,
61.
I'm giving 1 week time.
That's all right, but in the meantime, they should not proceed with 61, 62. Page 61,
61, 62,
they are submitting, my lord, again, they have initiated the process.
your stay, prayer for interim
Yes,
will be considered on the next interim date. I'll fix a date.
but why should,
I'll fix it.
I leave it to your lordship, but why should it not be considered now, my lord? Since my lord,
Let us
the
see
face of it.
what instructions he comes with. What
My
B
lord.
does, then it's senior counsel assisted by MS.
Ardeka.
Ardeka, then it comes to the petitioner, Mr.
RK Musari.
RK Mushari, then it's standing counsel BGC. Is allowed 1 week time to enable him to receive instructions. List the matter again on 2nd August.
My lord, may I pray subject to your tell that gradation list should not be cancelled in the meantime. The gradation list which has been finalized for the purpose of promoting headmasterism, that hope.
Same order in item 6.
I think so. Yes, ma'am.
6 and 54,
Date may be given, ma'am.
and both,
I've given you a date.
both will be tagged together, lordship.
2nd August.
Tagged together, both items.
My lord, your lordship will consider for interim prayer, madam, on that day. It may be mentioned.
Prayer for interim shall be considered on the next.
Obligation.
Same order in item number 6.
8. Here, lordship has directed me to take instruction whether the department has taken any initiative for promotion, lordship. My instructor, no initiative has been taken. Only the letter was written for lordship submission of that particular gradation list. But I have been told upon that the rule has to be amended. There some provision has to be amended, lordship. So it takes time. So nothing is happening right now.
Lord, my instruction is otherwise. The particulars of all the my lord incumbents who are eligible and qualified have been collected, and the gradation list for the purpose of promotion. Because now, my lord, it is a district-wise promotion of the headmasters, my lord. So that exercise is going to be carried out at any moment, my lord. They can come up with the process of my lord promotion. So, my lord, my last time, my respectful limited prayer before my lordship was that, my lord, they may consider our applications and our particulars, keep them as well as under seal cover, my lord. Without the leave of this court, my lord, they may not open, because as we are awaiting the judgment also, my lord. Otherwise, my lord, if the
judgment, lordship come.
Lord, I am not saying that we should be promoted right now, my lord. If that judgment, my lord, goes against us, my lord, then we have no case, my lord. Or if that judgment is coming in our favor, my lord, then we will be prejudiced, my lord, if these posts are going to be filled
So,
up.
but he's saying that they are not going to take any steps.
No, my lord, the process which they have started, my lord, may kindly see. My lord, may kindly see because this is his, my lord, with all respect to my senior friends, contention, my lord, what was page, my lord, at 100, annexure 13, my lord. Page 100, annexure 13, my lord, may kindly peruse the contention. This is a letter issued by the, my lord, Director of Secondary Education to the concerned Inspector of Schools regarding submission of the gradation list of eligible teachers for promotion to the vacant post of headmasters of provincialized high schools. With reference to the subject cited above, I am to request you to submit the gradation list of eligible teachers for promotion to the vacant post of headmasters of provincialized high school under your jurisdiction within 15 days as per the existing rules. My lord, this gradation list is being prepared for the purpose of promotion, my lord. Now the process has already been, my lord, initiated. Now, my respected friend has said that nothing is going to happen, my lord. Already it is, my lord, activated, my lord. The process
Today
has been
morning, I have been
activated,
told
my
by the
lord.
director that no, nothing has been initiated right now, lordships. Only the letter was issued for upgradation, for submission of gradation list only.
Now, my
The
lord,
rule has to be amended. The government is going to amend some rules, lordship.
Which rules?
That I don't know. I have not received any.
my lord,
lordship.
these
I have been
are,
told
these
over-
are not reliable
Lordship.
statement, my lord.
Can I record your statement?
That lordship, right now, I have to take a written instruction. Lordship may kindly.
My lord, they can
Sometime.
file an affidavit, my
Nothing
lord.
has been taken. That instruction, lordship may kindly, that no initiative has been taken right now for promotion.
Can I record your statement
That statement, lordship kindly record.
that you are not taking any further steps?
There no steps have been taken right now for immediate fill up of the
Immediately,
portion of this.
my lord, immediately they are not going to promote. My lord, there is a process under the rule, my lord.
Then you bring written instructions.
Yes,
My lord,
We'll take
Yes.
it up on day after tomorrow.
my lord, my lord.
day after Friday, Lord.
Okay.
My
But yeah, Buyan, Leonard Council for the petition. On request made by SMDC still and studying council,
Secondary.
secondary education. This the matter again on 28th. Come with written instructions.
Our presence also may be recorded, my lord. I am for
Mr. I
NCT.
along Leonard Council appears for the NCT
Yes,
and Mr. H. Hamal Leonard Council appears for the
UGC, my lord.
for the youths.
Obliged.
10.
Please, your lordship. My lord, the matter relates to the selection and appointment of state teacher, my lord, for the lower primary schools, my lord. My lord, what happens in this case, my lord? For lower primary teacher, my lord, marks obtained in 3 categories, my lord, required here. ACS pass marks, and then DLED, my lord, and then date, my lord. Including the marks in these 3 categories, my lord, my marks stands, my lord, 209.942, and the marks obtained by the respondent number 4, my lord, who is the selectee, he obtained, my lord, 209.914. So difference is, my lord, he is 914 and me, my lord, 942. Now kindly see the, my lord, impugn final select list, my lord. Page, my lord, 61. Page 61, my lord. Serial number 109, my lord. Manjurul Haq, my lord. And then total marks, my lord, here in the right hand side, 209.914, my lord. This is, my lord, difference of some points, my lord. Then kindly see, my lord, my statement in page number 8, my lord. Here, my lord, one issue, I inquired the matter in the office, my lord, and they had given me to understand that your economics marks, which you have secured in economics marks in betterment, that has been not included. My case is, my lord, minus the marks obtained in economics in betterment, still I stand, my lord, more meritorious than him. Because in the original examination, my lord, I was absent in economics because it was fourth elective subject, my lord, not necessary. And I appeared in betterment in that economics subject. They have said that we cannot include the marks in economics, in improvement. My case is, my lord, minus the marks obtained in economics in betterment, my lord, still I stand higher than him. And this is the, my lord, figure that I have stated in page 8, my lord. Last part, my lord. A says within bracket, my lord, minus economics 78.8, my lord. Page 8, my lord.
Yes.
At this stage, let notice be issued. The private respondent has been appointed on 25th of May 2023. Pursuant to the selection.
Who is the appointment order?
Appointment order, they have not annexed, my lord.
My lord,
They have challenged the appointment.
we did not, my lord, could not collect the appointment since the time is passing, my lord. And there will be, my lord, delay ground, and therefore, my lord, we have, but mentioned, we have stated, my lord.
Third, Mr.
AF NU Mullah.
AF NU Mullah, learned counsel for the petition. Para. Pursuant to an advertisement dated 11/2/2023, the petitioner and the private respondent number four apply along with others applied for the post of assistant teacher of lower primary school. Stop. It is the case of the petitioner that he secured 209.942% of marks in higher secondary,
In higher secondary,
comma,
DLA,
TLH
and then TET.
and TET. And the respondent number 4 secured 209.914%. Stop. However, the respondent number 2 oblique the Director of Elementary Education Assam recommended the case of the respondent number 4 despite the petitioner securing more marks. At this stage, Mr. B. Kaushik, learned standing counsel, Elementary Education Department submits that the respondent number 4 has been appointed on
25/5/2023.
25/5/2023. Para issue notice. Mr. B. Kaushik, learned standing counsel,
1, 2, and 3.
Elementary Education, appears for the respondents 1, 2, and 3. Stop. Petitioner will take service of notice on respondent number 4 by registered post AD within 1 week from today. Stop. List the matter after 4 weeks. The appointment of the respondent number 4 shall be subject to the outcome of this.
My lord, appointment and selection, my lord, in Dhamaji district.
That
In
was
Dhamaji district, my lord, may be mentioned.
appointment and selection of the respondent number 4 as assistant teacher
Assistant teacher of lower primary school in Dhamaji district.
of lower primary school in Dhamaji district shall be subject to the outcome of this.
Deeply obliged.
11.
Obliged.
My lord, my paper is lordship, my lord, with limited prayer, I approach the honorable court, my lord. I am not challenging the impugn order, my lord. But in the impugn order, my lord, annexure 4, I have been suspended, my lord, due to making some derogatory comments, my lord. Impugn order, my lord, 4, my lord, page 18, my lord. Lordship, may I read the order, my lord? In pursuance to the Karbi Angle Autonomous Council letter dated so and so, 29 June 2020, Dr. Harvey Ingti Katharpi, Assistant Professor, Department of History, Ruxin College, Bokolia is placed under suspension subject to the department pending duel of departmental proceeding in violation of the Rule 3 and Rule 7 of Assam Civil Service Conduct Rule 1965, which is liable to attack the appropriate provisions of Assam Service and Discipline Rules 1964. Dr. Harvey Katharpi, Assistant Professor, is allowed to draw suspension allowance as per the rule during the suspension period. She shall not engage herself in any professions or trade during the suspension period. I have not engaged anywhere, my lord. Dr. Harvey Inti Katarpi SN shall not leave headquarters during the suspension period without prior permission from her immediate superior in charge of her establishment. Ma'am. That is, my lord, in this part, my lord, I have not challenged the order. But even then, my lord, my restriction, movement has been restricted. My lord, with due permission, I can move. Now,
That's correct.
my lord, only thing is that I am a patient, my lord. 2014, I was one gynecomaternal problem, my lord. That has been again the recurrent remark, my lord.
So you take
Disease,
permission.
my lord.
You take permission.
No, I prayed for permission, my lord. I prayed for my lord to give a movement, my lord, outstation, my lord. They are denying, my lord.
Where's that?
My lord, that is first is my lord. That once 37 I have submitted, my lord. That one they have not accepted, my lord. Thereafter, my lord, next one, my lord, page 23, annexure 7, my lord. That was by sent by my lord, register report and handed over to my lord, them also, my lord. There have been, my lord, they have received, my lord. May I read the, my lord, representation, my lord. Everything has been specifically stated, my lord. What is the reason, my lord? And further also, my lord, I also need further, my lord, one, my lord, seminar, my lord, regarding my lord, research subject, my lord. That also will be required in future, my lord. So now present passport, my lord, for the medical ground, I come to Guwahati from the my lord, Bokolia, my lord. That has been not allowed, my lord. If I move also, my lord, if they come to again, they'll be take me, my lord, under different footing, my lord. Otherwise, the impugn order is a harsh, my lord. That I'm not under silence, my lord. Only I may be allowed to move, my lord, with due permission. That, my lord, reasonable restriction must be there, my lord, but cannot, my lord, violation of Article 19 and 21, my lord. They can restrict, my lord. I am the employee of that college. But not that way, my lord, I cannot go for medical treatment.
Yes.
Lordship will look into page 21, annexure 6, whether the petitioner submitted the proper application or not, my lord. She should submit an application for proper application that for that period she should once the leave, my lord. Lordship, annexure 6, page 21. With due respect, it is to inform that my so-and-so has informed, so I am going to Guwahati in a day or two for check-up. I may not join before vacation. That is not the application, my lord. The application should be seeking permission that I want to go on leave for certain period. That is not an application, my lord. She herself stated that she will leave without taking permission. That is the first point. And second annexure, my lord, there is no prayer that she will go for medical leave, my lord. See, if you wants to avail the medical leave, she should submit the proper application. Authority will definitely require consider, my lord, along with the medical certificate, my lord. No application has yet been filed, my lord. Without any application, my lord, how the leave can be granted? Lordship will look into the other annexure also, annexure 7, page 23. There is not a whisper that she wants to go on medical leave for a certain period, my lord. She should specify the period, that for that period, 7 days, 10 days, 15 days, she should specify it, then it can be only considered.
Yes.
What is,
I'll do my
prayer is 25.
But I'll do, my lord. Only thing is that first application was, my lord, that denied to my lord, receive the application, my lord. Second, my lord, I have sent the register post, my lord. Now they are coming to know that earlier also, my lord. That's why I have not specifically stated, my lord. If they permit me, court may direct, my lord, I'll specifically state where to go, what region, I'll submit all the documents, my lord.
You request for permission.
My lord.
That is
First I
that is
requested,
what
my
you
lord.
want.
First I requested,
Page
my lord.
25, if you lordship, page 25, there is no prayer. Page 25 prayer is that the denial of my application for permission to leave, even for medical treatment, is violation of fundamental rights. What is where is his prayer? Her prayer that I want to go on leave for certain periods. That application should be there, my lord.
This is a past application, my lord. They denied to acknowledge my application, my lord. So if they acknowledge, my lord, I can consult with my doctor when I can be available, my lord. So when doctor said that I will be available Guwahati for your treatment, my lord, then I will communicate the college again, my lord. If they say that not at all, how you can put it that, my lord? Then I have to consult with my doctor also. It is not that my expectation that is doctor may not be available at Guwahati, my lord. If they say, my lord, you will be permitted, provided you put that date. I'll put that date with consultation with the doctor, my lord. But they are not accepting my application. They are not listening to my prayer. Even verbally also I prayed. I am a college professor of the college, my lord. This formality is at all not necessary, my lord. In fact, my lord, because of that, they order, my lord, suspension order, my lord, they have put some restriction, my lord. That for medical purpose, for educational purpose, I cannot be restricted, my lord. This is a violation of Article 19 of the Constitution, my lord. There may be a reasonable restriction, not that, my lord, where it infringes the private right of right and life of the person, my lord. My lord, pass an order, my lord. I'll put that death with an application. Let them allow, my lord. Because, my lord, what if they have brought in the allegation? I'm not challenging. I have passing a derogatory comment. My lord, annexure 1 is a so-called. What kind of derogatory statement I have made? Not at all mentioned the so-called. Second so-called also they have not mentioned. What kind of derogatory statement I have made? These are
Okay.
all vindictious, my lord.
Heard Mr. M. Sarania. Learned counsel for the petition. Also heard Mr.
J. Sutia,
J. Chutia, learned standing counsel,
Karbi Anglong Autonomous Council.
Karbi Anglong Autonomous Council for the respondents,
3, 4,
3 and 4, correct?
my lord.
Lordship, I am appearing for 1 and 2.
And Mr.
D. Upamanya,
U. Komanya for the respondent 1 and
10.
1 and 2 only, isn't it?
Yes, Lordship.
Stop. Para. The petitioner was placed under suspension by an order dated 3/7/2023, issued by the Additional Director of Education, Karbi Anglong Autonomous Council, Dipu. Pending role of departmental proceedings. Stop. The order of suspension further puts a restriction on the petitioner that she shall not leave headquarters during the suspension period without prior permission from her immediate superior in charge of her establishment. But it is the case of the petitioner that she is suffering from myoma, isn't it? Myoma. And therefore, she made an application on 4th of July 2023 before the principal in charge, Lucasen College, Bakalia, for permission to leave station.
To Guwahati, my lord.
To leave the headquarters for treatment at Guwahati. However, the same was rejected. Stop. He also made an application, isn't it?
My lord.
Before the Additional Director of Education, KAC, on 10/7/2023, seeking permission to leave headquarters during the period of suspension. Being aggrieved, as she was not granted permission to leave headquarters. Petition is before this court by way of the present. Para. After considering the applications made by the petitioner, seeking permission to leave headquarters, this court is of the considered opinion that the petitioner should specify the period for which she is seeking permission to leave headquarters for medical treatment
For medical and other purposes.
and for her medical treatment, etc.
My lord, I have annexed one document, my lord. In future, I have to go for one seminar also, my lord.
That to make separate application.
My lord.
Accordingly, this petition is disposed of. Directing the petition to make a proper application,
My lord.
specifying the period of days required
My lord.
for her
For living station.
for leaving the headquarters
My lord.
for her medical treatment. If such application is made by the petitioner, then the concerned superior authority shall consider the same in accordance with the aforesaid
Petition dispose of, my lord, dispose of.
dispose of what's
My lord, may I pray, my lord? Now there is some modification going on, my lord. Principal, my lord, may not be able, maybe, my lord, approach the, my lord, the response number, my lord.
That's why I said before the
My lord, my lord,
superior office.
my lord, my lord. Hello, my lord.
Well,
May it please the lordship may kindly adjourn the matter for the day, lordship, and may list the matter in the next week, any date, lordship.
you have Mr.
MS Mondal.
On request made by MS Mondal, list the matter after 1 week.
Lordship may give the date, lordship.
You are adjourning the matter. I'm not giving dates.
Always, lordship.
13. Lord, may kindly pass over the matter for a time being, my lord.
Why?
Senior is on legs in another court, my lord.
What is this matter about?
And the petitioner was working as an assistant teacher at Gosaipur Nehru MV School, my lord. And then suddenly she fell sick on 19th of April 2023. And she was absent for a few days, my lord. And during her absence, my lord, the deputy commissioner visited the school premises and found her to be absent. And accordingly, the impugn order was passed whereby the petitioner's salary was reduced, my lord.
What?
To the impugn, by the impugn order, the petitioner's salary was reduced, my lord.
Page?
My lord, 24.
Were you absent with leave or without leave?
My lord, I suddenly fell sick, and thereafter I submitted my application. But I was sick, therefore I couldn't come to the school.
Yes. You on after some time.
Yes, ma'am.
Who appears for the other side? Upon you have any instructions?
Lordship, in this matter, Lordship, as on date, we don't have any instructions. We are awaiting our instructions. We have written to the department. Perhaps the government might. Lordship, we'll get our instructions. Matter may be fixed after some time, Lordship.
After some time.
Time meaning, Lordship, maybe listed after a week, Lordship, because we'll.
Let him get the instructions.
After a week. After a week, 10 days, Lordship.
But Mr.
SH Mahmood.
SH Mahmood, really counsel. Mr. Fukan, really.
Elementary education.
Elementary education shall take instructions. This after what?
14. Yes.
Need to clear the lordship. Lordship, the petitioners represented for their association. This is the 4th time they have appeared before this honorable court. So these petitioners represented for their association belongs to SC community people. Their association is Karimganj District Anusuchit Jati Parishad, affiliated under Assam. Assam Anusuchit Jati Parishad, having its office at Guwahati. It is an affiliated under this. Now, in the year 1992 and 1993, Lordship, a scheme was adopted by the WPT and BC department for allotment and distribution of an amount of rupees 10,34,000 for as financial assistance under the SCC plan for the welfare and educational upliftment of the scheduled caste community people. And accordingly, this fund was distributed at that time. And this educational development involves at the time was for opening and taking over primary school, for conversion of single teacher primary to double teacher, etc. And under for this purpose, 94 numbers of post of stipendary teachers were also created, Lordship. Now, Lordship, petitioners and these 94 posts, as per the petitioners' submission, were selected by the Subdivisional Scheduled Caste Welfare Board of Karimganj and Karimganj District Anusuchit Jati Parishad. This 94 teachers list was prepared. That is Annexure 1. I have annexed page number 27 and 28, Your Lordship.
Page number
27 and 28.
Here, my lord, WBT has been made party, but it's not reflected in post statement. Director of Welfare and Plain Tribesmen. Necessary party here, my lord.
Rahul, are you there? Huh?
It is sector and then master. Party goes in post statement. Yes, my lord, but I was not served the copy, my lord. This is
You will not serve a copy?
no, not copy, my lord. My name is also not there in the cause list.
Have you served a copy?
Lordship, copies were served by the flagging clerk, Your Lordship.
Finance and government, but here I am appearing for the WPT and BC, my lord. This is you should.
You furnish a copy?
My
Lordship. At this stage, Lordship may issue notice. Because recent judgment of this honorable court regarding these petitioners was of last annexure, Lordship, annexure that is two since 1996 is not complied with, Lordship. If Your Lordship kindly hear my submission, I will serve copy, Lordship. If Your Lordship permits. 10/5/2022 was the last order passed by this honorable court. That is two is not complied with, Lordship, till today. We have submitted two representations also.
What is your prayer in this petition?
My prayer is this, Lordship, there was a civil rule filed by this association in the year 1996, where Your Lordship kindly peruse annexure 2, page 29 and 30, where this actually what happened in this case, Lordship, those 94 teacher post stipendary posts which were reserved for appointment of SC candidate people, only 10 people of that list were appointed, and 84 rest of the 84 were appointed by non-SC candidate, Lordship. That was the main grievance at that time. Subsequently, they have filed one civil rule, and this honorable court directed not to distribute any fund to the non-scheduled caste stipendary teachers, school teachers out of the fund allocated.
and one more thing, my lord, in this, social justice and empowerment has to be made a party, because SC now comes under social justice and empowerment department. So they have to be made a party. And for SC, there is a different, Mr. R.M. Das is the standing council. So they, because this falls under social justice and empowerment.
Then you'll have to make necessary application.
Lordship,
You'll have to make an application.
yes, I will do,
Social justice and empowerment.
including social justice.
MS
As last,
is the Gupta,
as last,
the counsel for the petitioner, prays for how much time?
1 week. Lordship.
1 week time to enable her to make an application, praying for impeachment of necessary parties. Praise the Lord. Please, after 1 week.
15.
May I please, Lordship?
Lordship, this matter is regarding amalgamation, my lord. Director of Secondary Education by the order dated, my lord, 17/6/2023, my lord, has amalgamated Rahampur Girls LP School with Dongra High School, my lord, in
Page.
violation of Government Office Memorandum,
Page.
page, my lord, 12, my lord, annexure 1, my lord.
Where's your school?
Serial number 8, my lord, Dongra High School with, my lord, 1511 number Rahampur Girls LP School, my lord. This order was issued in violation of Government Office Memorandum dated, my lord, 3/8/2021, my lord. Petitioners file, my lord, the objection before the
Who is the violation of what order? 3/8?
3/8/2021, my lord, annexure 3, page 17, my lord. This is the office memorandum. Relevant portion is, my lord, page 18, clause 7, subclause 1, my lord. All the schools situated in the same campus shall be merged with the highest level of school. That is, if there is a higher secondary school, a high school, an ME school, and an LP school situated in the same campus, my lord. In our case, my lord, both the school are not situated in the same campus, my lord. Moreover, my lord, clause 13, my lord. Clause 13 says that, my lord, if 2 or more LP schools are located within a radius of 1 kilometer, then the LP school may be merged, provided that the number of students does not exceed 100 in each school. My lord, Rahampur LP school, my lord, is situated, my lord, more than 2 kilometers away from Dongra High School, my lord. Petitioners file, my lord, objection before the Director of Secondary Education, my lord. Annexure 2, my lord, page 16, my lord. Regarding his grievances, my lord. My limited prayer is that, my lord, issue notice and
You file an appeal.
yes. Yes, yes.
Under clause 19, appellate provision is there.
Clause 19 is there.
Yes, my lord.
In the notice.
Maybe director, my lord, until appeal is disposed of, my lord.
Director
Petitioners,
concerned will
should not
issue necessary order
disturb,
for
my lord.
amalgamation or
Observation
any
may be
disputes
given.
arising out of the order. The aggrieved institution public may appeal before the government in the secondary or elementary education department as the case may be.
But Mr.
HL Ashkar, my lord.
H.A. Laskal and a counsel for the petition. Also heard Mr. U. Sharma. Then standing counsel,
For secondary education department.
secondary education for respondents. One,
For respondent number 1, 1, 2, 5.
1, 2, 5. Elementary who appears?
And 3, 4. 3, 4, 6.
3, 4 and 6, madam.
And Mr. T. Bikul and the standing counsel elementary education for respondents, 3, 4, and 6. Stop.
No. And no.
Who is the petitioner?
Petitioner is the president of Rahampur Girls LP School, my lord. 1511 number, Rahampur Girls LP School.
The petitioner, who is the president of 1511 number Rahampur Girls LP School under Badmita Education Block. is aggrieved with the order of amalgamation of order dated 17/6/2023, by which amalgamation oblique merger of schools of Barbita district under the Shiksha Khetra scheme was effected. Stop. The petitioner school, namely Dongra High School, isn't it?
Dongra High School. Petitioner's school is Rampur Girls. Rampur.
Huh?
It is merged with the Dongra High School.
The petitioner school,
Rampur Girls LP School.
Rampur Girls LP School.
Rambo Girls LP School. The petitioner school has been merged, oblique amalgamated with the Dongra High School on the ground that the same has been done in violation of the office memorandum dated 3rd August 2021. Particularly clause within 7 within bracket 1 and
Close 13.
clause 30. Stop. Para clause 19 of the OM dated 3rd August 2021 provides for an appeal before the government in the secondary or elementary education for any disputes arising out of the order of amalgamation of the stop. Para. Accordingly, petition is directed to file an appeal before the secretary, school education department.
School education.
School education department within a period of,
It's 10 days.
in a period of 2 weeks from today. After comma, the secretary school education department shall consider the appeal filed by the petitioner after giving an opportunity of hearing to the petitioner and thereafter pass appropriate orders in accordance with law within a period of 1 month,
2 months.
2 months from the date of receipt
Also,
of the
one observation may be given. Till disposal of the appeal, petitioner's school should not disturb.
till the appeal is disposed of by the school, by the secretary school education. The merger of the amalgamation of the traditional school with the Dhura High School
Yes, ma'am.
shall remain suspended. With the, what's it?
Most obliged.
16.
May please, Your Lordship. The petitioner is entitled for her provincialization since 2013, Lordship. Under 2011 Act. Due to the some mistake done by the respondent number 3, it is the district elementary education officer. My name was not forwarded to the district level scrutiny committee. And one science teacher's name is forwarded as Hindi teacher. And now he is enjoying the benefit of Hindi teachers.
Yes,
My lord, is a provincialization under 2011 Act, my lord. And petitioner is claimed so late, my lord.
Huh?
Provincialization under 2011 Act. That DSA could be challenged, my lord, before.
what is it?
That this is just, my lord, notice of 2011.
The petitioner is entitled her provincialization.
You are Mr.
MK New Lordship.
Not MK New. Issue notice. Mr. J. Before.
J.
Before standing also. Elementary.
Yes, ma'am.
Education appeals for respondents 1, 2,
3, ma'am.
3. Petitioner to take steps for service of notice on respondents 4, 5, and 6 by the expert procedure. Respondents are allowed to file list after performance.
Obliged, please.
65 of supplementary leave.
Lordship, in earlier item, I appeared for response number 6, Lordship. Earlier method. Response number 6, item 16.
Item number
16.
okay, SR Barol, this is
16 है,
based on the response number
6.
Sixty-five.
May please remark, my lord, matter related to medical college admission in the first year MBBS course, my lord. Petitioners, my lord, belong to scheduled tribe community, my lord. Accordingly, she appeared in the NEET, my lord, 2022, my lord. Accordingly, my lord, Lordship may come, my lord, page 24, annexure 6, my lord. The scorecard of the, my lord, NEET 2023, my lord. Lordship made total, my lord, all India ranking for counseling, my lord. The 230550 is my all India level position, my lord. In case of my lord, scheduled tribe, my lord, in all India, my rank is my lord 4022, my lord, 4022, all India, my lord, rank as a scheduled tribe, my lord. So, my lord, in my lord, I am in the state of Assam, my lord. In medical, I supposed to get in my lord reserve category candidate, my lord. It will be my lord in between 2 digits, but total string seat for the reserve category is 142 probably. So my, if according to my calculation, after scrutinizing the score, my lord, rank, my lord, my name will be by 99, maybe 98, my lord. According to this, my lord. Now, my lord, the Lordship may come to the page 25, annexure 7. The date of counseling has been notified, my lord. So, my lord, for the central counseling, my lord, it will be start from my lord last from 20, my lord. And for the state, my lord, from 25th, from tomorrow, my lord. So prior to that, we have to register, my lords. Have to register, my lord. For registration, my lord, Lordship may come to the page 26, annexure. That format is required, my lord. To register myself, my lord, that I am claiming STP category seats reserved for the STP, my lord. So this kind of certificate is required, my lord. This has been issued by the sub-divisional officer or DC, my lord, on verification of the type certificate of the person concerned, my lord. That has been issued to me, my lord. This is issued to me, my lord. After issuance of this in the 17/7/2023, my lord, again concerned, my lord, sub-divisional officer called me over from my father, asked me to return the, my lord, that annexure fee format certificate, my lord. So I, my lord, asked the, my lord, why it is required to be given, but there is a direction from the deputy commissioner not to put signature in the fee format, my lord. So, my lord, when I declined to return, my lord, they said that they will file FR before the police to taking legal action. Then accordingly, keeping photostat copy, I have returned, my lord, signed one, my lord. So, my lord, this is my case, my lord. I am belong to scheduled tribe community, my lord. And this is required, my lord, to claim a seat under STP quota, my lord. And without this, I cannot register, my lord. From today, my registration is going on, my lord. Before prior to 25, I have to register. So today is the registration date, my lord. From tomorrow, the counseling will be start, my lord. Who have opted for the national level quota, my lord, central full quota, except that they will be considered state quota, my lord. Now, without this, I cannot register, my lord. My prayer is Lordship may direct to the respondent authority to return the this one, either issue a fresh one, so that I am enabled to get admission in the, my lord, quota reserved for the scheduled tribe.
How can a direct issuance of a?
My lord, they cannot deny, my lord. When my lord, Lordship may come to the my caste tribe certificate, my lord.
But how can this court give a direction?
Because.
And why are we approaching so late?
No, my lord, only because 18 I have written, 19 I have approached, filed the petition, my lord, probably. 20 I have filed, my lord. And 19 came to the council, my lord, 20 I have filed. And secondly, my lord, earlier also this was happened, I have annexed an order, my lord. Annexure 9, my lord, page 27. Similar situation, my lord. But that time, page 29, my lord, with paragraph number 3, the direction of this honorable court, my lord. That time it was not issued, later on issued, that petitioner got admission. Now, present time, they have issued, they take back the certificate.
These are different facts and circumstances.
My lord, that time it was not issued. Court has directed to issue or show reason why you are not issuing. So that later on it was issued, got admission, now we become a MBBS graduate also, my lord. Here, my lord, Lordship, my lord, my prayer is, my lord, Lordship may come to the prayer person, interim person, my lord. Either Lordship may, my lord, I may be allowed to take provisional admission, or may one seat for the STP may kept reserved, my lord. Or may not be filled up, my lord.
Yes.
My lord, here only DC can, my friend will have to seek an instruction why it was withdrawn. But my lord, I will come to some other facts. Facts is, my lord, here, I'm making a presumption, my lord, that Devunla Horonia, this surname, Soronia, my lord, was taken out from this ST list. What happened, my lord? Earlier, we were by a notification, government notification dated 28 February 23, we were issuing this. This was put under challenge in a PIL and 2 writ petitions. And during the course of this, we have withdrawn this. My friend was a party to that case also. I am just placing a copy of this Soronia. So, my lord, whether now this Borokochari falls within the Soronia, they fall within this, that has to be ascertained, my lord. And who is, my lord, the state level scrutiny committee is the competent authority. They will have to decide, my lord. And I don't know why DC, but this Soronia, my lord, Soronia Kathari, that has been withdrawn by the government. PIL, I have a order just I'm placing with your lordship and the earlier notification. That part, my lord, I'm just,
my lord,
as an officer
I am
of the
aware
court,
of that order, my lord. I am aware of that order, my lord. I was one of the, my lord, respondent, my lord. That order is different, my lord. It's not come in the way to this, my lord, issuance of this annexer V certificate, my lord. Lordship may come to paragraph 9 of that order, my lord. Paragraph 9, my lord.
1 minute.
Paragraph 9 is, my lord. এতিয়া এইটো খালি কমিটিত কলি কৰিব যে ইহঁতে
Yes.
My lord, this is a checkered history, my lord. The petitioner is belong to scheduled tribe Borokosari community, my lord. Her surname is Soronia, my lord. In the process of, my lord, transformation of the Assamese society, formation of the Assamese society, tribal people become Hindu, my lord. In the process of become Hinduism, my lord, that way some people say that, my lord, claiming that they are different, my lord. Economic government has decided to issue tribe certificate differently, my lord. That is under silence. They are selling the, my lord, you until unless it is incorporated in the, my lord, presidential order 1956 or 1976, my lord. You can't issue a certificate without the presidential promulgations. The state government had decided to issue certificate as a kosari, which is not kosari is not separately included in the constitutional scheduled tribe presidential order, my lord. That's why that has been, my lord, negated. It is not negated. She is not belong to. These are not belong to scheduled tribe community. If want to separate them from the Bodo Kosari community, you have issued a presidential notification. Whatever required to be researched, needs some, my lord, the RGI, Registrar General of India has to, my lord, refer. Then, my lord, cabinet will take decision. Then presidential order will come, my lord. That process has not been followed. That's why it has been, my lord, struck down by the Guwahati High Court and not by the. They have withdrawn the notification, my lord, government itself. So this is issuance of notification is does not affect because it will be withdrawn by themselves. And here also judgment said you can do whatever legally you can do, but you cannot substitute a scheduled type order or name without the presidential notification. That was the issue, my lord. So my type certificate issued in 2013. That is not issued under their notification 2018 or that has been withdrawn, issued, does not affect me, my lord. Lordship may come to my tribe certificate, my lord. Lord, page 20, my lord. They issued in 2013, my lord. Nobody has challenged it. Until unless this certificate is cancelled, my lord, my status cannot be, my lord, by mere saying that they cannot deny my status. Somebody has to challenge, nullify it, my lord, that I am not belong to so and so. When it is issued by the concerned authority, signed by the deputy commissioner, issued by the tribal sangha, when they were the authority to issue, you cannot deny my status. Their, my lord, order is nothing, my lord. Only their inclusion of that Kosari word has been nullified by the High Court, my lord. State government has no power to exclude in the presidential order without following the due procedure of law. That is the case. How my learner friend is projecting this case, my lord, because of that they are denying. It cannot be a case, my lord. Or it is that after the notification, it was issued to me on the strength of the notification as a Kosari. That is different. Here not Kosari. Here is Bodo Kosari. Bodo Kosari is a, my lord, in that notified in the presidential order, my lord. It is in 2, my lord. Till number 2, my lord. So, my lord, I don't know why they have withdrawn, my lord. As on today, my lord, they cannot deny my status, my lord. What if it is the, my lord, court proceeding, that has, my lord, no effect with me, my lord. They only cannot issue as a Kasari. They want to separately issue as a Kasari. They cannot issue because this is not, there is no presidential notification. That's why this one challenged by the Kolbari Youth Welfare Association. They have challenged. State government has no power to substitute a list or include a list.
Yes.
How that is different issue. It's not coming the way in this repetition, my lord.
My lord, here, why it was withdrawn? DC or SDO, my lord, has to, my lord, give a clarification. My friend will let him get the instruction, my lord. And my lord, if the situation arises as such, that the caste certificate is doubtful, then it is to be referred to the committee.
State level committee.
State level scrutiny committee, they will, my lord.
Who is complaining my certificate is doubtful?
Let him seek instruction, my lord, why it was withdrawn.
But the counseling is starting tomorrow, isn't it?
My lord. He will get it, my lord.
Either I may be allowed to provisional admission or one seat for me may be kept in vacant till decided of the case. It may be decided immediately, my lord. Otherwise, they will fill up all the posts. My came maybe, my lord, in 2 figures, my lord. There's a 142 seats for the reserve category. All India rank, my lord, 4022.
Yes, sir, Baro.
Lordship, I have to take instruction. Why it was returned back from the petitioner, Lordship. Tomorrow, Lordship, tomorrow.
What about the counseling?
Counseling part, Lordship, the department, concerned department will take care of, Lordship.
Which department?
Because
Who appears for health?
health department, Lordship. They are made a party, Lordship.
I will just.
But their name not shown, Lordship. I don't know whether a copy has been served or not, Lordship.
The copy has been served.
The name not shown. In mid. I can take instruction on the part why it was returned back, Lordship. But counseling part, only the department has to answer, Lordship.
That is my lord, that counseling that must have been notified. It will already started for my lord, Central Kolkata. Steps will be by tomorrow, my lord. So I have to register by today itself. Or maybe by tomorrow morning.
Otherwise, Lordship, I will try to get the instruction before Lordship is rising, Lordship. For telephonic instruction. Today itself, Lordship.
Okay, 2 o'clock.
Lord.
Two will take up.
My lord,
You inform the health department.
Lordship.
my lord. High level.
Yes.
Lordship, this matter is about constitution of school management and development committee. My name have been selected by the deputy commissioner. It is duly approved by the guardian minister. But the writ petitioner raised the objection before the honorable court that in violation of the notification dated 2016, my name has been approved by the guardian minister and the deputy commissioner. And his another contention is that I am politically connected. That is why I am not eligible to become the president of SMDC. So, Lordship, first time coming to the notification dated 2016, which is a page number 13 of my IA.
Yes.
Yes, Lordship, the first contention is that I am politically connected. And this political affiliation is explained in the clause number 4 of this notification, which is a page 13, clause 4. Clause 4, Lordship, any person who had contested any election of panchayat level, public parliament or assembly election in last 20 years should not be considered for the post of president, vice president, even if he or she is fulfilled all other criteria as indicated above. And there is a one table and just below this clause 4. And this table says that in the one local educated reputed citizen having no political career as a president.
So Lordship, this clause, the clause says that the person who has contested election in panchayat level or in parliament or assembly election, he is not eligible. And then again, this clause is saying that the political career having no political career. So the political career is defined in the clause, in the same clause, in the beginning of the clause, that is, if he contested election in any level in the last 20 years, then it can be considered as a political career. And Lordship, yes, I was connected with a political party, primary member of a political party, but I had resigned, page number 17. Annexure C, page 17 of my application. And this is duly accepted. Lordship may appreciate the date of resignation letter, 26/10/2022. And the order which they have challenged, whereby I have been selected as a president, it was issued on 16/12/2022. That is 2 months before I have resigned. I have detached from.
Here it says one local educated reputed citizen having no political career.
Yes.
So you have a political career?
No, no. I was a just primary member of a political party. And this membership, Lordship, political inclination, if Lordship considered in broader sense, that in political inclination this way or that way, everyone is associated with politics. But the career, it has got a wider meaning. There is a person who is holding a position in a government by virtue of his political power, or he is holding any portfolio, any profitable position of any organization by virtue of his political power. Only then it can be considered as a political career. So I am not going to this aspect, and my case is that I have resigned. That is admitted. 2 months before that I have resigned. So question of building up a political career does not arise in my case also. Lordship, this story can be understood like this. Being a council, I am arguing before your Lordship on the strength of the license issued by the Bar Council of India. And if I surrender this license tomorrow, then I shall not be entitled to argue before your Lordship. So similarly, when assuming that he has a case on political career, till that I am associated with the political party, he has a case. But here, 2 months before I have resigned.
But then you had a political career.
Political career, Lordship.
Despite your resignation.
No, I don't have a political career. Yes, I was associated with a particular political party just as a member. And I had resigned also. So the question of building a political career does not arise, Lordship. And second issue is that, Lordship, they are relying on the 2016 notification that the selection process laid down in the 2016 notification is not duly followed. Lordship may peruse the page number 15.
Yes.
The inspector of schools, after consultation with the principal, headmaster, and local people, will forward 2 names to the director, secondary education, Assam, for each president and vice president, with the recommendation of the deputy commissioner within a period of 30 days. After considering the names, the director, secondary education, will provide the list to the government with his comment for selecting the single name after comparing the data of both the candidates and the government, will approve the committee. Lordship, as per this selection process, as per this notification, that the director shall recommend, the final recommendation shall be made by the director to the government with his comments. Then government will approve. I am assuming that he has a case as per this notification. If he has a case, the director shall be directed by this honorable court to approve his name. If he has a case, the government shall be directed by this honorable court as on the basis of that notification. But this notification has been modified. And by virtue of the subsequent modification, the director has become powerless and the government also has become powerless. The power is vested on the deputy commissioner. The subsequent notification empowered the deputy commissioner to modify the selection process at his level, and for that, no approval is necessary from the government or the director. Lordship, this is that subsequent notification is on the page number 22. Of my application. In partial modification of the guidelines for constitution of School Management and Development Committee issued by government notification number ASF 416-2014/116 dated 24/6/2016. That notification just I have referred. And the letter number so and so dated so and so. The deputy commissioner is hereby empowered to select the president and vice president of School Management and Development Committee (SMDC) of an educational institution of the concerned district with approval of the guardian minister. So guardian minister is with the deputy commissioner is empowered, and once he will select, the guardian minister will approve the same. So my case is that my name has been selected by the deputy commissioner and that has been approved by the guardian minister. So if a person, if the writ petitioner relies on the 2016 notification, assuming that he has a case, under part he has made a prayer that the director shall be directed. The Lordship.
Yes.
Paragraph 5, your lordship. Below, your lordship. There is no dispute on the fact that the petitioner appellant was not selected for direct recruitment as provided under the Rule 7. The main thrust of the petitioner appellant is that due to passage of long period of time as an honorary teacher, he is entitled to be regularized. In this connection, it is submitted that some teachers were also appointed in an honorary capacity with the petitioner appellant. It is also indicated by the learned counsel for the petitioner appellant that the petitioner appellant had appeared in a selection for direct recruitment twice, but he never knew the result of the selection. That is to say, the petitioner appellant is not selected through the selection process as provided under Rule 7 of the rule. Much stress has been given on the fact that the approval given by the inspector of schools for appointment of the petitioner appellant in honorary capacity on a request of the committee of management held a promise to the petitioner appellant for regularization in future. In this connection, our attention has also been drawn to one of the annexures in which the inspector of schools had once requested the director of secondary education Assam to sanction posts so that the honorary teachers might not suffer. On this basis, it is submitted that the petitioner appellant had a legitimate expectation for regularization. In this connection, again, it is submitted that there is no provision for regularization as such. In fact, if any honorary teacher was regularized, that would obviously be without any provision under the law. The learned counsel for the petitioner appellant has placed reliance on a decision of division bench of this court reported in so and so. Now, the matter related to honorary assistant teacher in primary schools. In similar circumstances, it appears that the appointments on honorary basis were made by the committees of management. The committees of management again seems to have sought approval of the inspector of schools without there being any such provision. However, while considering the matter, this court observed that such cases of honorary teachers involve a human problem. The honorary teachers were driven to such a situation that they were ready to work in honorary capacity. Such teachers had put in long years of service. It was also considered that due to their age, it might not be open for them to go in the open market and secure appointments. After highlighting the above factors, this court observed the issue is of considerable difficulty to this court in adopting any principle to spell out the rights of honorary teachers. From this observation, it is clear that it will not be laid down as law that such teachers acquire any kind of right for being regularly appointed. In the above situation, the court, it appears, invited suggestions from the two so and so. On the basis of suggestions put forth by the Council of Workers, found feasible to allow the benefit of regular appointment to such teachers who had put in 10 years of service. So far as those teachers who had not completed, it observed that there is nothing which can be stated to have occurred in their favor. From the bare perusal of the order passed by this court as indicated above, it is difficult to hold that any rule of law had been laid down or any such ratio could be deduced from the decision that a right accrued to the honorary teachers for being appointed on regular basis. The decision was rendered on the basis of suggestions which were given by the council of both the sides. Maybe it is something sort of concession, but the basis of decision was again so that no suggestion of, so your lordship, on honorary lordship teachers, they cannot be regularized because they are not appointed against any sanctioned post, your lordship. And they are not appointed through any following the rules, your lordship, not on regular basis. They were appointed by the managing committee. And lordship, I'd also like to place, there is an office memorandum, your lordship, where it is stated that government is therefore not liable for the regularization of the services of the honorary teachers who were appointed by the managing committee after the provincialization of the schools. We also have an office memorandum, your lordship, where they have spoken. Yes. Okay, I place another judgment allotment to 2004 to GL. It's a paragraph 16, 1-6.
Yes.
Paragraph 16. There is yet another aspect of the matter. The elaborate discussion that has been proceeded was necessitated by the very strenuous arguments advanced by the several counsels appearing for the petitioners, though the question raised in the present cases appears to be in a way covered by a division bench judgment of this court in the case of Abdul Bari versus the state of Assam. The division bench considered the entitlement of an honorary graduate teacher of a secondary school to seek regularization of his services. The honorary appointment made by the managing committee on so and so was approved by the jurisdictional inspector of schools by his order dated so and so. On the basis of the aforesaid approval and long years of service rendered, a claim for regularization was raised. which was expressly negated by this court by holding that in view of the provisions of Rule 7 of the Assam Secondary Education Programs Services, Rules 1982, the managing committee had no power to appoint teachers in a provincialized school. The division bench in Abdul Bari's case considered another division bench judgment in the case of so-and-so and clarified that no law was laid down in Kunjalota's case to the effect that honorary teacher who had rendered 10 years of service or more would be entitled to the benefit of regularization. In Abdul Bari's case, the doctrine of legitimate expectation and equitable principles were urged in support of the claim for regularization, which were also considered and negated, Your Lordship. Following the law laid down by the division bench in the case of Abdul Bari and also in view of the conclusions reached in the present case, it must be held that the petitioners have no legal or equitable right of regularization. Consequently, this branch of writ petition must be held to be disclosing no merit for interference. Your Lordship.
Yes. Montal.
My lord, so for my lord, the citation referred my learned friend, my lord, 1999, 3 GLT, page 31. Lordship will kindly see, my lord, at page, my lord, 4 by page 4, my lord, last few lines, my lord. Page 4, internal page, my lord. Nine line, my lord, above. On the basis of, Lordship got it. In our page 4.
Page
On-
4.
On the basis of, my lord,
Para 6.
para 5, my lord,
There are 5.
para 5, last 4 lines, my lord. Para 5, last 4 lines. On the basis of,
Teaching is not telling.
my lord,
Lordship.
para 5, my lord,
Paragraph 5,
last 9 line, my lord,
next page, Your Lordship. Next page.
page 4, internal page 4. On the basis of, right hand side, Lordship will find. Last 10 lines, my lord.
10 lines, Your Lordship.
On the basis of,
Yes.
on the basis of suggestion put forth by the council of both the sides, it was found feasible to allow the benefit of regular appointment to such teachers who had put in 10 years of service. Then, my lord, insofar as those teachers who had not completed 10 years of service, it was observed there is nothing which can be stated to be have accrued in their favor. From a bare perusal of the order passed by this court, as indicated above, it is difficult to hold that any rule of law had been laid down or any such ratio could be deduced from the decision that a right accrued to the honorary teachers for being appointed on regular basis. The decision was rendered on the basis of the suggestion which were given by the council, both sides being invited by the court may it be requisite something for short concession, but the basis of the decision was akin to that no suggestion or concession is coming from the side of the council for the state in this case. In so and so above circumstances, in our view, it is difficult to order for regular appointment on the basis of the decision cited above. Now, so for this, the first 4 lines is concerned, those who have completed 10 years.
No, the law was laid down in Kunjala.
Yes, no law laid down. Now, that is the decision 1999 by this honorable court. And so far the Umadevi is come, 2006. And ML Kashori is 2010. And Intercollege Lordship has seen Karnataka as 2019. So Supreme Court has cleared this situation by Umadevi, ML Kashori, and Intercollege Court.
Your hurdle is that you appeared in the interview.
Yes.
And you were not selected.
Yes. She was not selected.
but the selected person did not join in my
Doesn't
post.
matter whether
Yes,
the selected
yes.
person joins or not. That is a different issue.
Now, my lord, another case. Good goal. Open this. এটা গুবি দিয়া না এটা দিয়া my lord, in latest case by our high court, my lord, State of Assam versus my lord Upendar, 2020 5 GLT 605. Lordship, here, Lordship, kindly see, my lord,
This is
paragraph
work
21.
charge- This is work charge master role implicit.
Yes.
Our case is an honorary teacher.
Honorary teacher. Now, ratio regarding my lord, 10 years, my lord. That ratio, 10 years is my
Will
lord,
that ratio of 10 years apply to honorary teachers?
my lord.
That's the whole thing,
Yes,
which has been appointed by the school management committee.
management committee.
That's the whole thing. You check up on that law and come back.
Yes. Now, my lord, in any case, Lordship, kindly see page, paragraph 22. What has been held by this honorable court by the division bench. Paragraph 22. Lordship got it.
No, this is a different issue. This one has.
This
no-
is regarding, my lord, those who have not, my lord.
This is a different issue.
Yes.
We're talking about honorary teachers.
Honorary teacher.
If you have some citations, you can study and come back.
My lord.
Heard Mr. M.U. Model.
Yeah.
Also heard MS.
D. Musahari
D. Musa.
for secondary education department.
This letter again, after 1 week, 2 weeks,
My lord.
how much time do you require?
My lord, 1 week, my lord. It is the. Obliged.
Obliged, Your Lordship.
24, 25, and 26.
In this matter, in item number 26, Lordship, we'll have to file affidavit, Lordship, so some time may be granted. That's all.
Item 26 is your
Yes,
case.
yes.
Yes, my lord. No affidavit has been filed in item number 26, my lord.
Yes, sir.
What offer is that? Third Mr. Protocol and counsel for the petitioner in WC 370 of 21. Also heard Mr. S.S. Goswami,
Yes, SS Goswami.
counsel for the petitioner in WC 1162 of 22. Mr. Navilda, the standing counsel,
Higher education,
higher education, praise for
3 weeks time, that's
2 weeks time to file counsel affidavit in WC 1162 of the petitioner. Praise the Lord.
27.
27, Lordship, in this matter.
Yes, David, do you have the records?
Anytime.
Are you having the records?
Lordship, I have the records, Lordship, from the college, Lordship, selection process, the records. of
Okay,
the-
and liberty may be given, Lordship, to let me to go through the records, Lordship, and then matter may be fixed in a very short notice. Lordship.
Okay.
Let me go through the records. Lordship.
But Mr.
Vijay Das, Lordship.
He does, then the concept of the petition. Also heard Mr. Islamilda, the standing council, higher education.
That's 8,000.
Order, Mr.
Lordship, I am appearing for respondent number 4 on behalf of our movement.
Mr.
H. Bezgurwa.
S. Vespuria, legal counsel, appears on behalf of the R. Mahinder, legal counsel, to respond number 4. Who appears for the private respondents?
Madam 3 and 6, madam. I am doctor for 3 and 6.
And the third legal counsel for respondents, 3 and 6.
3 and 6.
And Ms. R. Devi, legal counsel for the respondents,
For 5 and 7, Lordship.
as well as H. Kumar, legal counsel.
UGC. 8. I am for the 8.
Public, it's for number 8. 8 is UGC.
UGC.
When?
Lordship on 31st, Lordship, if this not inconvenient to Lordship.
31st.
Much of that.
65 of supplementary.
The government.
In this case, Lordship, additional deputy commissioner by his letter, because joint secretary department of WPT and BC, Lordship, asking some clarification, Lordship.
এখন দিদি করি কপি এখন
না, এটা-
it's all different.
Oh, this is regarding clarification.
Yes, Lordship.
But why did you ask the certificate of the petitioner back?
Due to non
Annexure
non
6.
receiving the clarification, Lordship, the deputy commissioner has not issued the certificate.
Yes, Gogoi.
Tomorrow counseling will be held. Now only those candidates who have got the requisite certificate to show that they belong to a particular caste, they can only upload and participate. Otherwise, they will have to apply the general candidate. And Lordship is aware, my lord, we have a limited time, my lord. We will have to fill up all the seats. We cannot keep waiting for someone. So Lordship may direct the deputy commissioner to take a call by tomorrow, my lord. And it places before the court. They will have to expedite this.
But then his counseling will get delayed.
The counseling will not be over in one day. It cannot be, my lord. For all the categories, it cannot be.
But registration has to be done today.
By tomorrow, my lord.
By tomorrow. At the time of counseling, my lord, they will have to upload it.
Okay, then Barman,
Yes, sir.
you come with instructions tomorrow.
Tomorrow, yes.
Okay. But M. Sarana,
Instructions, Lordship, regarding issuance of certificate.
yes.
But Lordship,
Then, my lord, one for either, my lord, I may be allowed to provisional admission or make a packet.
Tomorrow we'll take care of it.
but Lordship, but due to non-availability of the clarification from the WPT and BC department, deputy commissioner has not issued the certificate, Lordship. So unless Lordship, WPT and BC department has clarified the stand, Lordship.
My lord, our clarification is, my lord, the PIL. We have already withdrawn it. Saroniya Kasari will not get that. Is, we have already withdrawn, my lord. We have placed this withdrawn letter that before the law division bench, my lord. That is what I have placed before your lordship. And that is what observed in the PIL order, my lord.
Not against me.
Kasari is no more, my lord, in the list. That has been withdrawn, my lord.
Of course, STP.
STP. That is what it reflects in the order, my lord.
They wanted to create a separate class. They were not allowed. They will go to remain to the original class. What is the difficulty, my lord? That, my lord, in 1996, my lord, lordship, bear with me kindly. 1996, course was supposed to be recognized as a ST, my lord, by my lord ordinance, my lord. That 2 times it was allowed. That was parliament, my lord. It was not city. That's why it was not approved, my lord. After that, my lord, one Moiti case came to the Guwahati High Court division bench, my lord. Then she was also denied to admission in the, my lord, ST reserve seat, because during the, my lord, ordinance, that he took out a copy certificate of ST social status, my lord. When the admission is going on, my lord,
Then they denied. Then one case came, my lord, that time, my lord, what is the earlier status? Earlier to say OBC, she will go to OBC, my lord. My earlier status, I am to belong to schedule type by Borough community. They want to create a separate community.
My lord,
They have not created, it will go to the, my lord, earlier status.
Now, committee.
See, the issue is this. He's saying that the additional deputy commissioner has asked back the annexure 6 certificate.
My lord.
Correct.
Malik.
Now, according to the deputy commissioner, that was asked back, seeking clarification from you.
My lord.
Why don't you give your clarification? You will take up the matter.
My lord, I will instruct my department to expedite it, and my lord pass an order. I will just, by tonight, I will try to send the clarification so that tomorrow DC can send a clarification, madam.
Okay, have heard Saranya, then we council. MS Didi Barman, then the council. On instruction submits that the annexure within the annexure Roman 6 issued to the petitioner. Is it Roman 5 or 6?
My lord. It is issued by the sub-divisional officer, my lord.
That's why is it Roman 6 or 5?
My lord. 5, my lord. 5 has withdrawn, but 4 has, my lord, directed to withdraw, my lord.
No, page 8.
Yes.
Annexure 8.
Annexure 8, page 26.
Yes.
That had been issued with me. That is my photocopy. Original was with the, my lord, sub-divisional officer.
That's why this is annexure 5, isn't it?
Yes.
Schedule 1, annexure 5.
8, my lord.
Yes. In
Annexure 8 is the copy, my lord. That annexure fee certificate. Page 26.
That the certificates of class for the petitioner was called back by the additional deputy commissioner for seeking clarifications from the Department of Tribal Affairs, in as much as persons belonging to Sarania Kachari community, which were earlier notified as ST within bracket P, has already been withdrawn. Stop. Mr. Ardhar, Leonard, Standing Council, Tribal Affairs, submits that appropriate instructions will be given to the additional deputy commissioner, Tamalpur Sub-Division. Stop. He therefore prays for listing the matter again tomorrow to enable him to receive instructions.
My lord, the top of the list, my lord.
List the matter
Tomorrow.
again on tomorrow.
My lord, the annexure, my lord, the my tribe certificate has not been recalled, my lord. That is annexure, my lord, that is there, my lord. They have not recalled the annexure 3. They have asked the, my lord, the original copy of the annexure 8.
Annexure
8.
5.
Annexure 8 and my lord, that format annexure 5.
Annexure 8 to the
My lord, maybe top of the list tomorrow, my lord, because tomorrow I have to register.
It's too late. Post list is already out.
Then, my lord, one post maybe can be reserved. Either I may be allowed to.
You can make
Which
a
the
mention,
admission?
you can make a mention tomorrow. Yeah, in fact, one of the other case, EWS quota case is coming up tomorrow. So there also there will be a hearing tomorrow. It may be taken up along with that case, yes. I will inform you, madam. I will get it right.
67. I not a copy. I'm praying for a copy of
So
the
just a
order.
copy of this order to Mr. R. Then it's Standing Council, Tribal Affairs Department, using the process.
I never.
67 hearing.
Yeah, please, here in this case, my lord, I have prepared a short course of notice, 4 short course in a one page, my lord, for your lordship's convenience, my lord. Since the issue is the same, my lord.
What is this?
This is the shockers notice, 4 shockers notice are issued, my lord. First one is the general, my lord, shockers notice in respect of 74 colleges, my lord. Subsequently, my lord, another shockers notice dated 14/5/2019 issued. Institution has not submitted requisite documents in compliance with shockers notice dated 21/2/2019. Thereafter, they have approached before the honorable court. Accordingly, honorable court disposed of the writ petition with the direction to issue the fresh shockers notice. Now, that's why we have issued another shockers notice on 10/3/2021. That is, approved faculty list is not as per NCT regulations of 2014 as 3 teachers are part-time. And 11/6/2021 is the final shockers notice made. For compliance of the shockers notice dated 10/3/2021. So in all the shockers notices, there is no other reasons, my lord, except academic faculty list. And so far as, my lord, in the writ petition, my lord, what is their prayer, my lord?
Yes.
In their prayer, they have paid for quashing of the order dated 13/9/22 and appellate order dated, my lord, 20. Uh, 13 appellate order, my lord, that is ARS page 31, my lord.
Yes.
31/9/2022, as well as the regional committee order, my lord. Which was passed on 31/1/2022 along with order of 26/8/2019. Wherein the recognition order of the college has been withdrawn, my lord. And subsequently, they have also prayer in parent number D, my lord. The respondent number 3 shall not be directed to dispose of the representation dated 24/3/2023 submitted by the petitioner institution with the sticking order after giving adequate opportunity of hearing to the petitioners. That one of the prayer is that their representation must be disposed of, my lord, since they have complied with the.
Where was that representation?
That is at page 93, my lord. Now, my lord, you also got it. Now we are pleased to inform you that the college has fulfilled the necessary requirements as mentioned in your order number so and so dated 13/9/2022. As per your order, we have appointed principal having PhD degree, necessary documents enclosed herewith. 2H college has appointed 3 new teachers, 1 in core paper, 2 other pedagogic and content knowledge documents of these 3 teachers with the along with the appointment and joining letter is enclosed herewith for your kind information. We have updated faculty list which has been approved by appointing university, copy enclosed. Since the admission process will start from month of May 23, our college has fulfilled the requirements stated in your order dated 13/9/22. I would request you to kindly consider our prayer and earliest possible so and so inconvenience. Since, my lord, appellate authority have passed the order, my lord, final order under the section 18 of the NCT Act, my lord, how the regional director will reopen or review the order of the appellate committee, my lord. Number 1, my lord. Number 2, my lord, in their against their representation, we have already disposed of that representation, which I have annexed with in our counter affidavit, my lord.
Page?
Count 123, my lord. Your lordship, what? That the recognition of the college.
See, Alam,
My lord.
one side you are saying that since the appellate authority has already considered the matter, how can the regional director consider the representation?
Yes, my lord.
Then how could you have disposed this representation?
Since we have in your letter, we have responded that they have exhausted the remedy. And as per rule, my lord, which I have already provided to your lordship may kindly peruse our rule, my lord, of NCT rule, my lord, which I have already given to you.
Which rule?
National Council for Teacher Education.
Rule.
Rule 1997, my lord.
The rules may be called the National Council for Teacher Education Rule 1997, my lord.
Yes.
My lord, it founded Rule 10, my lord, appeals.
Yes.
Any person aggrieved by an order made under section 14, 15, or section 17 may prefer an appeal in the form 1 appended to these rules to the council within 60 days of issue of such orders, along with a fee of rupees 10,000 payable with the memorandum of appeal in the form of cross demand draft drawn in favor of the council, provided that an appeal may be admitted after the expiry of said period of 60 days if the appellant satisfied the council that he had sufficient cause for not preferring the appeal within the period of limitation of 60 days. Procedure of disposal of appeals. On receipt of memorandum of appeals, the council shall call for the records of this from the regional committee concerned which passed the order appealed against, and after giving the appellant a reasonable opportunity of being heard, passed such orders as it may deem fit. 2. The appellant shall be entitled to represented by an employee or officer of the appellant institution. 3. The council shall decide every appeal expeditiously as possible as ordinarily every appeal shall be decided on perusal of documents, memorandum of appeals within written argument, if any affidavits, and after hearing oral arguments as may be advanced. 4. The council shall endeavor to dispose of every memorandum within a period of 3 months from the date of its filing. 5. The council shall not ordinarily allow more than 3 adjournments in any appeal. So these are the preconditions for disposal of the appeals, my lord. And we have already decided our appeal, my lord. Thereafter, they have again approached before when they have exhausted the remedy, they have again approached before the regional director that they have appointed the full-time teacher, my lord, as well as principal, my lord, which is in violation of the NCT Act and regulations, my lord. And
You may direct the appeal, the representation to be placed before the appellate authority.
that is not possible, my lord. How appellate authority, since the remedy already existed.
By staying the decision of the appellate authority.
That is up to your lordship, my lord.
That is the better we are.
But I have to pay for dismissal of the instant petition, my lord.
Yeah, that is the.
Since they have in the meantime, they had violated also the provisions of section 17(4), which after they admitted the students, my lord, which is contrary to the provisions of the law, my lord.
That was when the order was kept under appearance. Correct, if I'm not wrong.
Yes. In that case, my lord, I'd like to place one judgment of Honorable Apex Court 2011 3 SCC 238, my lord. 2011 3 SCC 238, my lord. And another 1986 supplementary SCC 166, my lord.
Yes, 238, what is the issue?
Para 41, my lord, regarding the time limit of the regulations, my lord. In that case, my lord, I just like to submit para number 41, my lord.
Yes.
Para 41, my lord.
Yes, we did.
We further hold that the provisions contained in section 14 and the regulations framed for a grant of recognition, including the requirement of recommendations for state government, union territory administration are mandatory, and an institution is not entitled to recognition unless it fulfills the conditions specified in various clauses of the regulations. The council is directed to ensure that in future no institution is granted recognition unless it fulfills the conditions laid down in the act and the regulations, and the time schedule for processing for application of the regional committee and communications of the decisions on the issue of recognition is strictly adhered to.
Since they have violated the regulations, my lord, since initially there is an academic faculty, their recognition withdrawn, and then they have again approached before this honorable court for show-cause notices and etc. My lord, subsequently we have withdrawn the recognition. After withdrawal of recognitions, now they have come up with the faculty list, my lord. In fact, it is a violation of regulation, my lord. Regulations are formulated under section 32 of the NCT Act, my lord. In my second judgment, my lord, 1986 supplementary receipt, which my lord, page 170, my lord. Last one I have marked it, my lord, in blue ink, my lord. These institutions were established and the students were admitted into these institutions despite a series of press notes issued by the government. If by plea of the court, we direct the government to
Which
permit
one
them-
you are reading, which one?
170, my lord, last.
Yes.
I have marked it, my lord, in blue,
Yes.
my lord.
Yes. Yes.
May I read, my lord?
Yes.
These institutions are established and the students are admitted into these institutions despite a series of press notes issued by the government. If by fact of the court, we direct the government to permit them to appear at the examination, we will practically be encouraging and condoning the establishment of unauthorized institutions. It is not appropriate that the jurisdiction of the court either under Article 32 of the Constitution of India or Article 226 should be fettered away for such purpose. The teachers training institutions are meant to teach children for impersonable age, and we cannot let loose on the innocent and unworthy children teachers who have not received proper adequate training. True, they will be required to pass examination, but that may not be enough. Training for certain minimum period is a properly organized and equipped training institute is probably essential before a teacher may be duly launched. We have no hesitation in dismissing the petition with cause. That is my humble submission, and I pray for dismissal of the petition since they have violated the regulations which is comes under section 32 of the NCT Act.
On reply, I would like to submit only one thing. The point before Lordship, my lord, is whether, my lord, the show-cause notice was issued in respect of the ground on which, my lord, the recognition has been withdrawn. That is the simple issue, my lord. And I did not find, my lord, the reply coming from the other side that this is the show-cause notice which was issued in respect of these two grounds. My lord, leaving all the, my lord, the grounds earlier apart, my lord, the last ground was that the principal of the college was not qualified. And secondly, there is shortage of one teacher. My lord, the respondent has failed to show, my lord, produce before this court any show-cause notice by which I was given this, my lord, show-cause notice on that. And on top of that, my lord, show-cause notice comes at the later stage. Section 13, I have already placed before your lordship of the 1993 Act. My lord, the Supreme Court has also said, my lord, the post-recognition status and the pre-recognition status is, my lord, two different concepts, my lord. So far as Section 13 is concerned, that is specifically for the, my lord, the school, colleges or the institutions, my lord, for which the periodical inspection is required to be made. And that inspection will be done, my lord, jointly by the institution personnel. Everything will be videographed, and any deficiency is found, that will be pointed out to the college, my lord, authorities to rectify that. If they fail, in that case, my lord, the show-cause notice comes. Now, my lord, my categorical statement, no inspection has been done and no opportunity has been given to me pointing out to cure the my lord, deficiency whatever I have. On top of that, my lord, there's no so-called notice issued to the my lord, institution before my lord, taking my lord, the action, my lord, or passing the order either by the my lord, original authority or by the appellate authority. And that was the case my lord, throughout. So therefore, on this honorable court on 2 earlier occasions has stated, my lord, initially my lord, that has been said it should be kept abeyance, and if you the first order of the court, my lord, if you find any ground or any ground for rejection, you give him a appropriate so-called reply, and then you proceed. Until then, the order of my lord, withdrawal was my lord, kept in abeyance. There's a specific order that still stands, my lord. This event, my lord, that direction has been violated by this by the respondent authorities. As my lord, I don't want to repeat, my lord, Lordship has seen, my lord, they issue a so-cause on this particular ground, and then they affirm the order by the appellate authority or by the original authority on some other ground. Now here, the so-called notice was issued in respect of deficiency of educational qualification of 3 persons, and then some discrepancy with regard to the dates, which I have replied. And then they have given this saying that the principal doesn't have the qualification and one sorted without specifying. And long litigation, the harassment that has been given, what the institution thought. All right, let us accept whatever you have been saying. These are the requirements. We change the principle. You are saying that 1 person is shortage of 1 qualified teacher. We have appointed 3. And we said that you consider it. They did not consider, but thereby our approach to this honorable court cannot be denied. We have approached this honorable court challenging the original order as well as the appellate order for a writ of certiorari, and thereafter the pair of mandamus is there to directing them to consider my representation. That I have already fulfilled all this question, and if you find that there is still we are in deficiency, point it out to us or give us a so-called notice, then you proceed. So therefore, the submission is that this requisition be allowed by setting aside the order of the appellate authority. Page 83. This order will be set aside, and as per the earlier order that had been passed, my lord, they may be directed to consider my representation, and if I still deficient in any of the provisions of the act or the rules, they may give me an opportunity to make up the deficiency.
Your representation is
yes, my lord.
93.
Page 93. That has been disposed of. That they have disposed of, saying that we don't have power. Rather, my lord, in the affidavit, they say that we have you have already adjusted the remedy available. So writ petition, my lord, definitely, my lord, when there is no other alternative remedy, my lord, the writ petition is maintainable. So we have come here. But while verbally submitting, my lord, it is said.
So you want to make a representation?
My lord?
You want to make a representation?
No, not at all. My prayer would be, my lord, to set aside this, my lord, the appellate order, as has been done in the earlier case. And my lord, if they find, my lord, any of the deficiency on the part of the institution, as per rule section 39, they'll give me an opportunity to rectify the defect. And if I fail to do that, they'll issue a so-called notice. I'll reply to it, and thereafter they can pass the order. Representation is already pending, and what is the content of the representation? The content of the representation is that whatever you have pointed out the deficiency, that have been rectified. So you take a decision. That much is my representation. Already, I have cited one judgment, the copy, AR 2012, SC 2232. AR
AIR 2012 Supreme Court 2232. On the first day heading app. Yes, there, my lord, I have referred to the paragraph 22, 23, 24. Apex Court, after my lord, inspection of all the provisions of the Act, my lord, these observations are made there. Yes. Page 22. Once recognition has been granted by the regional committee to an institution, the council has to ensure that such recognized institution functions in accordance with the 1993 Act. To achieve that objective, the council has to get inspection of recognized institution done periodically, and if such institution is found with wanting in its functioning as required, that recommend to the institution the remedial action to be taken by it as a result of inspection. In view of the above statutory scheme, it is hard to appreciate the litigious approach of the council and the present controversy. If the council feels that its function of inspection under section 13 may be performed by regional committee, it can so provide by invoking section 26 or section 27 as the case may be. What is clear from the provisions of the 1993 Act is that post recognition and institution acquired a different position. On recognition by the regional committee under section 14 and on affiliation being granted by the examining body, once the recognized institution starts functioning, the interest of teachers, employees, and the students intervene. In order to ensure that the recognition institution function in accordance with 1993 Act, the 1997 rules, the regulation, and the conditions of recognition, and at the same time functioning of such a recognized institution is not disturbed unnecessarily, the provision for inspection and follow-up action pursuant thereto has been made in section 13. By section 13, as a matter of law, it is intended that the council ascertains whether the recognized institutions are functioning in accordance with the provisions of 1993 Act or not. But this has not been done. 13, they did not inspect. They did not give pointed out any deficiency if I have. On top of that, they did not issue any so-called notice, my lord, as mandated in section 17, my lord. And this is then secondly, my lord, two of the judgment, my lord. Of course, these are the, my lord, one from Delhi High Court and the other is from Madhya Pradesh, my lord. AIR 2013, Madhya Pradesh 43. Yes. There I am referring to, my lord, paragraph 5, 7, my lord, these are the facts, my lord, 15 and 16. My lord. Paragraph 9, my lord. Paragraph 9, no. All also, my directly, my lord, paragraph 15, my lord. Paragraph 15, withdrawal of recognition is a just. Yes. Withdrawal of recognition is a drastic measure as observed by the Honorable Supreme Court in paragraph 24 and 27 of the Yes. In the case of National Council of Teachers Education Supra, the relevant paragraphs so and so are quoted, my lord. Then, my lord, paragraph 16. In our opinion, in the case of withdrawal of recognition, it is obligatory on the part of the council to follow the provisions of statutory rules 1997 and the provisions of Act 1993. In the present case, the aforesaid provisions have not been followed. Apart from this, the council has passed an order of withdrawal of recognition on the ground that petitioner has no requisite infrastructure and books. However, the claim of the petitioner as otherwise. As per the petitioner, it has sufficient infrastructure and library, and that has also been certified by the authorities. In such circumstances, in our opinion, it was obligatory on the part of the respondents to follow the provisions of 1993 Act of 1993 and rules of 1997 in letter and spirit, because there is contravention of the aforesaid provision. Hence, the impugn order dated so and so are contrary to law. Consequently, the petition of the petitioner is allowed, and the impugn order dated so and so is quashed. So, these are imperative provisions, my lord. Then, my lord, in the year 2020, Delhi 145, the grievances mentioned in paragraph 6, my lord, paragraph 6, my lord. The primary grievance of the petitioner is that the so-called notice was issued in respect of 8 violations. However, the order which has now been passed on 23rd June 2020 is based upon fresh violations which were never put to the petitioner in the so-called notice. She submits that, in fact, the so-called notice itself dates back up to 2016, and no fresh so-called notice was issued consisting of these 4 new allegations, which form the basis of withdrawal of the petitioner's request. Exactly the same situation here, madam. They have been doing it everywhere, madam. Paragraph 12. A perusal of the record shows paragraph 12, madam. Yes. A perusal of the record shows that the new grounds contained in the 313 meeting dated 25th to 27th February 2020 and reflected in the order dated 23rd June 2020 were not specifically a part of the so-called notice which was given to the petitioner earlier in 2016. In any event, the said grounds were also not put to the petitioner for the petitioner to be able to respond and satisfy the authority. In respect of the compliance thereof, neither the minutes nor the final impugn order considered the document which the appellate authority had directed the petitioner to file there. Consequently, because of that ground, this has been set aside. Paragraph 14. Accordingly, the withdrawal of recognition as per minutes of 313 meeting, the petitioner communicated via the impugn order dated 23rd June 2020 is set aside. The petitioner shall issue a fresh so-called, etc. on the new grounds, whatever they say. So both the cases are on the same thing, they did not follow any of the rules, and the so-called notice was on different ground, and ultimately order has been passed on different grounds. Yes. That's all.
Only, my lord, just only one submission that I have. Regarding the inspection, my lord, your lordship may kindly peruse 111, my lord, in my reply mail. That is there in clause 7, my lord, your lordship may kindly peruse.
111.
111, my lord. In page 111, my lord. 111, my lord. What is the procedure, my lord? That is there, my lord. Clause 7, my lord. 8, 9, 10, 11, my lord. These are the procedures how to inspection will be. That is my submission, my lord.
The results of B.Ed has been declared, and I have placed the documents the other day. They have been asking me the status of the college so that the student can be admitted. If I miss this, again, the entire college staff, everyone will suffer. You were saying last date, something is there? Last date has not been notified as yet, but they have given us 13/7/2023 as the last date of submitting the particulars, my particulars. That we have could not give because it is suspended. In fact, Lordship has suspended the appellate order, but there is a rider that I will not be able to take the admission. So
Yes, so therefore, my lord, the entire, my lord, I have been facing the.
I'm disposing it off, I'll write in the. I'm allowing the petition. Giving you liberty.
Yes.
Obliged. I have a submission, Lordship. That respondent number 7, Lordship, I am appearing, Gibruga University, Lordship, is in a formal party. And the instruction is they are supporting the case of a repetitioner, Lordship.
Majumdar, our
Lordship.
Yes. Disposed. Okay. But you're not getting the order today. Because today there's a reference and then some other. thing.
29 of daily list, admission.
May I please, your lord? But in this case, respondent number 1 has filed one affidavit in opposition.
Respondent number?
Respondent number 1 has filed one affidavit in opposition, Lordship. Lordship, may kindly allow me 1 week time to file the.
You're Mr.
M. Ahmed.
Mr. Mohammed, then the council petition is allowed 1 week time to file reply to the counter affidavit filed by the respondent number 1. List of the 1.
I learned.
30.
May it be also. Also, today the petitioners have filed the affidavit in reply to the affidavit in opposition filed by the state respondents. So probably Lordship, the affidavit in reply is not in the record because during the course of the day I have filed. Already I have filed. So let the matter come after a week, Lordship. As your Lordship's convenient.
Mr. Dekal and the council for petitioner submits that he has filed affidavit in reply to the counter of the respondent number 3. Today, so. Is to verify and place the same on it. And list the matter of, let it be 2 weeks.
That's it, that may be fixed. Lordship. After 2 weeks, Lordship, I need. If it is possible on a hearing day, Lordship. 10th of August, Lord. Reply, Lord.
31.
Kindly also putting matter for timing. There's a index in another report.
Okay, we'll see. If time permits.
32.
What is using actually?
May I place to Lordship? Lordship, matter may be possible for the timing. My senior legs in another.
Instruction awaited, your lordship. Instruction awaited. Letter has been sent, communication letter has been sent to the concerned department. Your lordship.
Okay, you are Mr.
SM
SM.
Jinnah.
Heard SM Jina, and the council for the petitioner. MS.
P. Das on behalf of P. Nair, correspondent number 6 and 7.
Appearing on behalf of Mr. P. Nair, London Standing Council BTC.
SSA.
SSA.
SSA 6 and 7.
Public respondent 6 and 7. Is allowed 2 weeks time. To receive it. Yes, after 2 weeks.
Deeply obliged.
That is a Lordship. In this case, Lordship, petitioner was appointed as a president of the
Lordship, I am appearing on behalf of the respondent number 7. Lordship, we are supposed to file a counter affidavit. So Lordship, unfortunately, today we don't have the counter affidavit. So your Lordship may kindly allow us some time to put the counter affidavit, Lordship.
Actually, affidavit is not required in this case, Lordship.
It's not up to you. They want to file an affidavit, they'll have to file it.
Last occasion, they have take time, Lordship.
Yes.
There are many times.
You are Mr.
B. Borgohai, Lordship.
But Mr. B. Borgohai.
Lordship, one more occasion should be given to us.
Mr. Your good name.
N.A. Majarbuya, Lordship.
NM
N.A. Majarbuya.
Azarbuya. The council, what is phone number?
7.
7. Is allowed, how much time?
That's a short debt.
Lordship, 4 weeks.
Not
That's
4
not-
weeks.
And they have
2 weeks.
that's a 1 week.
2 weeks time to file for job. This stuff. It's-
34.
Highly obliged.
It's in this matter, respondent have supposed to file affidavit, Lordship. Department has. But till now, not affidavit has been filed, Lordship.
Which respondent?
Thirty-four.
Elementary, who is suffering? But so that I can. So J before the notice, stunning council elementary education. 2 weeks, right? Yes.
After 1 week, Lordship. After 1 week, Lordship.
2 weeks.
35.
First week.
35.
Government was asked to sort for the instruction, Lordship. Your job teacher, Lordship, and they were working since 1994, Lordship, and 91 school was provincialized and they were left out, Lordship. Thereafter representation was submitted and that my case was not considered, Lordship. On last occasion, the
Still awaiting instruction.
relevant document was sought for. We have filed in a form of affidavit before the Honorable Court. And the learned court has asked them to for instruction.
Mr.
Lordship,
You're Mr.
S. Muni.
Yes, Muni, can you counsel? Mr. B. Kaushik, standing counsel. Secretary.
Secondary, madam.
Secretary Education Department. It is allowed. How much time?
2 weeks, madam.
2 weeks time to receive this. This documents.
36.
Much obliged, your Lordship. Much obliged.
Here in this case, my lord, we are going to file counter affidavit measure. So I may be allowed another 3 weeks time later.
Only the thing, my lord, a date may be fixed because regarding the admission of the student in the B.Ed college. my
J. Ghosh, learned counsel for the petition. Mr. Ayala, learned standing counsel NCT is allowed. How much time?
3 weeks time. my
3
lord.
weeks time to pay counsel. Praise the Lord. This the matter. 21st August.
My date can be fixed.
21st August.
Lordship obliged.
37. May I please, Lordship. This matter, Lordship, notice was issued, Lordship, fixed for instruction. Let
Yeah,
it come
everything-
after 1.
We are awaiting instruction.
Yeah, Mr. Hurt, Mr.
AU Ahmed.
AU Ahmed, learned counsel for petitioner, Mr. Fitzpatrick, standing
Lordship, we
counsel.
fix a date before 10th of September, Lordship, because the advertise will be published and 10.
If the advertisement is published, madam, nothing will remain in the repetition. Lord. They want the advertisement to be published.
Then,
After 1 week, Lordship, I will try. I'll
so
satisfy.
if
Their basic prayer is, madam, there are vacancies.
you know what is happening, isn't it? You know that the advertisement is going to be published.
Let it be after that, madam.
Then let the instruction come up, Lordship.
What did I say? P. Kaushik, the standing counsel. Elementary education
Madam,
is allowed. How much time?
2 weeks, madam.
2 weeks time to receive. This document is
38.
In this case, only 2 weeks time was given to them to file the affidavit in reply in the department. no affidavit has been filed. Moreover, my lord, the respondent number 6 of this case has filed another WBC in connection with this case, same issue. This case may be taken at least along with that matter.
You're Mr.
R. Islam.
Art R. Islam, then the counsel for petition. Who appears for respondents?
And for respondent number 6, Lordship.
He has filed the writ petition. Yeah, writ petition.
Elementary,
Yes.
Mr. Tegu was there.
We have not received instruction on that. It will be after 3 weeks.
Mr. B. Kaushik, the counsel. Elementary education is allowed 3 weeks. Time.
3 weeks.
Contract. List of 3 weeks along with WBC number
3368-2023.
3368
2023. Deep love life.
46 or
In this petition, my lord, I have challenged the impugned order, and accordingly, my lord, impugned order stayed. Of course, my lord, I was not allowed to hold the charge of headmaster, but BO was, my lord, given the charge to hold for time being. Now, the question involved in this case, my lord, whether in the event of amalgamation of both LP and ME school, the teachers who were working in LP school are otherwise eligible, my lord, to be promoted to the post of headmasters of the ME school. This is the question involved, and the other day when the government is directed to obtain instruction.
Why is it coming for orders today?
Today, my lord, I don't know why it has come. Possibly when the government is to produce instruction. Or lordship may do one thing, my lord. May I suggest, my lord, this is the matter for admission.
1 minute. Who's respond number 9?
Respondent number 9, she did not appear. In spite of notice being served.
Notice is not yet served.
Please have one again. I have taken steps as directed by the court twice.
The order passed in favor of respondent number 9 has been put to challenge.
Anybody appearing for respond number 9?
Nobody appearing.
Can you take first steps?
As your lordship pleases, my lord. But facts remain that, my lord, I have taken steps twice.
Twice.
Yes. If necessary, my lord, I will take step once.
Can you take dusty service?
As your lordship pleases.
I think that will be better.
I think it will be better.
My lord.
Mr. A.K. Puffer and counsel for the petitioner. Request for taking first steps for service of notice. Upon the respond number 9, declared justice. Petitioner shall take first steps for service of notice on the respond number 9 by the chief service to the registry of this court. Within a period of 1 week.
The 2 weeks, my lord.
Within a period of 2 weeks. Thereafter, petitioner shall file an affidavit. This is the matter. After
And interim order, my lord. Interim order dated 28/10/2021. After something, please.
47 and 48.
None appears for the petition. Please stop the 2 weeks.
October Metro 31. 31.
Thirty-one.
31.
Lordship, dispute here is lordship with the lordship regarding correction of date of birth. So this petitioner lordship,
Who appears for Seba?
yes. And
Mr. PC Sutia appears for one.
yeah, lordship,
He was there, my lord.
presence
I
of
have been
respondent
told that
is-
as the petitioner told him that they will be taking adjournment. He left, my lord.
Is that correct?
Sorry, lordship,
Adjournment logo বুলি কৈছিল।
I didn't inform lordship. I didn't inform. Anyway, lordship, the presence of respondent number 3 is necessary, lordship. He is a headmaster, lordship, who received the lordship first application in the year 1984 itself. So he has not appeared, lordship, no affidavit has been filed.
That's up to him. Notice has been deemed complete.
Yes,
But Mr.
J. Kolikar.
J. Colliton and the council. None appears on behalf of the Seba. Please stop the 2 weeks.